I am down with viral fever. Serial number 47, I am down with viral fever. Serial number 47, final hearing category.
My lord.
I am down with viral fever. Can my lord accommodate me for 2 weeks? Serial number 47, my lord, I am mentioning the matter.
At least. Second, sir.
Serial number 47. I am down with viral fever.
Let's wait for agreement with after 2 weeks. Yes, item 1 you call. Number 1.
Serial number 47, my lord.
What happened?
I am down with viral fever.
When it repeatedly 5 times, Mr. Devanand, you 5 times you have told us that you are suffering with viral fever. It has already been adjourned.
Obliged. I am grateful to the court. I am grateful to the court.
Your Honor, serial number
What is
49,
it?
if we mention.
Just a bit, madam, don't follow the footsteps of a senior counsel. We have given he is exempted category. Mr. Devanand belongs to an exempted category. You are a young
Right.
person. You have to go a long way. Please have some patience. Until
Obliged.
you tell us that you are going for a movie at 11:30, we will adjourn it right away.
Obliged, Your Honor.
He is suffering from viral fever. Are you suffering from viral fever?
No, Your Honor.
Please wait. Let's begin our day with something constructive, right? As we told you that the council, because of his age, belongs to exempted category. Therefore, we have entertained, and he is suffering from viral fever. So tell us that you are above 60 years of age and you are suffering from viral fever. We will immediately adjourn the case. You want an adjournment, right? You
Yes,
don't want
Your
to
Honor.
argue. So what is the urgency? What the urgency should be taking up a case, right, madam?
Yes, Your Honor. I will wait for the matter to be called.
Yes. No. Oh, what happened? It's covered, right? It's covered. Oh, yes. This intra-court appeal under section 4 of the Karnataka High Court Act 1961 has been filed against an order dated 25th August 2021, passed by the single judge, WP number 8625/2021. Paragraph when we taken up today, learned senior counsel for the appellant fairly submitted that the controversy involved in this appeal is covered by a division bench judgment of this court dated 1st of April 2021, passed in WA number 461/2020, within bracket C-RES bracket close, in lieu of then right for the reasons assigned in the aforesaid judgment, and with a view to maintain parity, comma, the appeal fails and is hereby dismissed. You should go try your luck in this case also. One more SLP to you. Yes.
For admission, number 2, Bhargav D. Bhatt.
My lords, I appear for
What
the
happened,
appellant.
Mr. Devanji? You are down with viral fever, we hope. Oh, good. Yes. Good. Yes. Yes, please.
My lords, we are challenging the order of the CSTAT passed on 6th of April 2021. The issue involved is, my lords, availability of Sunvat credit on towers and shelters. We are telecom service providers, my lords. We use these products to provide our services all throughout India. My lords, similar matters are pending before this honorable court, where the honorable court have admitted the appeals. These appeal numbers are Central Excise.
Just 1 minute. Learned counsel for the admin submit that the appeals in which similar which is involved in the instant appeal arises for consideration have already been admitted for hearing. In view of a court's submission, the appeal is admitted on following such counsel questions. How many?
My lords, what we can do is, my lords, at page number 278, the order which admitting the appeal in case of Vodafone, which is CEA 32 of 2018, the same questions may be incorporated.
You make such a so many questions of law. All right, 1, 2, 3, 4, and 5. This is page 277, right? Yellow. List for analogous hearing along with CEA number
32 of 2018 and 5 of 2019. Also, my lords, there is a department appeal against the same impugned order, wherein they have challenged the questions of whether the extended period of limitation can be invoked or not.
CEA number
50 of 2021. 50. Yeah.
Yes, 5.
Much obliged, my lords.
Here for appellant, my lord, your lordship, transfer pricing issues are involved, my lord. Question number 3, 4, and 5 requires consideration, my lord.
3, 4, and 5. The 3 eyes and nothing. Appeal is admitted on following substances.
Number 4, the KV Arvind.
Lord, the assessee, my lord, is a BMTC. Lord, the dispute before your lordships, my lord, is whether, my lord, the assessee, my lord, entitled, my lord, to be considered, my lord, as a charitable activities. Lord, no doubt, my lord, under section 2, subsection 15, my lord, it falls within the general, my lord, the activity of, my lord, the general public utility. But the proviso says, my lord, if that activity, my lord, is for a fees, my lord, it is, my lord, comes out of, my lord, that ambit of charitable nature.
1 and 2. KV Arvind.
Number 5, CH Anmati.
Appear for appellant, my lord, same, my lord, the transfer pricing case only, my lord. Question number 1, 2, 3, my lord.
Number 6.
6, I represent. I represent petitioner, my lord. The impleading application way back in the 2018 was filed, and that office has raised an objection. The proposed impleading applicant is a contractor. This is a project of for a drinking water to the 3 taluk, including Kolar and Bangarpet, Malur. 2006 project.
No, what is the office objection?
Office
What is
objection.
the office?
On the impleading application, office sought for rectification. There is a small mistake are rectified. And so far as service of
rectified.
I will rectify it, madam. I will rectify, and respondent number 8, they have to answer because they are
Please rectify, we will consider.
I will rectify.
Within how much time?
Only 1 week, on Monday it can be called, so that
the right counsel for the petitioner undertakes to comply with office objections within 1 week. List immediately thereafter.
My lord, I appear for the petitioner, my lord. Today, my lord, I have served the copy on Mr. Ramesh.
Right counsel.
May I make one submission in serial number 7, my lord?
1 of 20 has been supplied to Mr. M.K. Ramesh, learned counsel, who appears for respondent number 3 and 4 today. In view of a postal submission, office objection is ignored.
May I make one submission, my lord? This matter, my lord, students have filed a writ petition for enforcement of the order, which is impugned in this writ petition. Your lordship may recall yesterday some batch matters which my lords have posted to 8th of February on the submission made by Mr. Gowdy's colleague. This matter also, my lord, may be called on the 8th. We were actually...
Yes, madam. All right, list on 8th of February 2022.
Along with WP 52425 of 2019.
Whenever you are there, no? You
My
are
lord.
there, no? To tell us.
Yes,
You are there on that day to tell us that it should be taken up along with
Please.
some other days.
Please.
Number 8, the case Naresh Santosh, government advocate.
What is it? Okay. What is it? So, all right, which time is granted to comply with office?
Number 9, the Siddharth Kumar.
Appearing for the appellant in this matter, my lord, weeks time to furnish PF.
Number 10, the Ajay Kumar, yes.
My lord, I appear on behalf of the appellant, my lord. My lord, I seek a week. My lord, serial number 10, my lord. I appear on behalf of the appellant, my lord. My lord,
time is granted.
please, my lord. My lord, there's an interim order passed by my lords. The same may be extended, my lord.
Oh, that's the reason you are not paying process fee, right?
No, my lord, this is for the third time.
The third time it is coming up because there is an interim order and you don't want to pay process fee and get the interim order.
My lord, I have taken necessary
Interim
steps.
order, yes. Interim order will carry some continue till next date of hearing. Yes.
11,
For petitioner, my lord, in this case, the petitioner has questioned the detention order passed by the respondent number 1, my lord. Petitioner has filed application for IA number 1 of 2021. That is allowed by this honorable court on 24/1/2022, my lord. This honorable court has passed a direct government to file application. They are not filed objection.
24th January 2022. Therefore, no orders are required to be passed. Yes, Mr. SPP, what do you want? So when you are supposed to file it, Mr. SPP learned SPP 2 undertakes to file objections to the additional ground positively within 1 week, based on 9th of February.
My lord, this is already detention order passed on 9/3/2021, my lord. That will be expressed on 8/3, my lord. Kindly after last date of hearing, this honorable court has given a direction to file objection to 8th, my lord.
8th February.
Much obliged, my lord.
8th February.
Please, my lord. Much obliged, my lord.
File it, sir. What is that?
Number 12, the Muhammad Tahir.
Lordship, appearing for the appellant, Lordship. 12 and 13 are connected, Lordship. Like this, there are another 3 appeals are there, Lordship, on similar point. And this all may be connected, Lordship, and may be posted together, Lordship.
You have to comply with office objections. Do it within 1 week. 1 week's time is granted to comply.
May I give the appeal numbers, Lordship?
List along with.
In message box, I have sent the appeal numbers. I can repeat also here, Lordship.
Please repeat.
1881/2021, 1882/2021, 1892/2021, Lordship.
List along with. Yes.
Number 14, the EI Sanmati.
Your Lordship, your office objection is that, Your Lordship, I have filed application for amendment and for additional document. Lord. The office objection is that I have not served the copy. I have already served it, Lord.
Mr. Ramesh.
Yes, sir.
Government advocate.
Yes.
You received the copy?
Yes, sir. I have received the copy.
All right. Mr. EI Sanmati learned counsel for the petition submit. They have only supplied copy of IA 3 of 21 and IA 4 of 21 to learned counsel for respondent number 3. In view of a further submission, office objections ignored. When do you want this Sanmati?
Your Lordship, the application for amendment as well as the additional document, my Lord. At the time of filing the writ petition, my Lord, I was not having copy of the agreement, my Lord. So,
Ramesh, what do you say? Amendment will allow?
Basically, the government has to say this with regard to fixation of fee. He has to serve the government.
What is there? Like amendment has to be allowed, right?
Yes, amendment could be.
Word on IA 3 of 21, taking into account the nature of proposed amendment and for the reasons stated there, IA is allowed. Additional documents filed by the IA 4 of 21 are taken on record. In result, IA 4 of 21 is allowed. You will have to file objections. Learned counsel for respondents pray for and are granted 3 weeks time to enable them to file objections.
Your Lordship, one submission, my Lord, this copy of agreement, my Lord, given by them only, my Lord, government advocate only, they will not be having any objection, my Lord.
No, we have allowed your application.
Your Lordship, I will file the amended petition within a week time, my Lord. It may be taken up next week, my Lord.
Amended petition be filed within 1 week.
Yes,
they have to file objections, right?
Yes, my Lord.
So that's why we have given them 2 weeks time.
Yes,
you know what will happen. Again, they will seek time in next week.
Yes, sir.
He is not even praying for time. We are granting him. What to do? He did not say that he want to file objections. We are granting him time. What can be done? So we have granted him 2 weeks time. If he doesn't respond, then we will see what is to be done.
Yes, Lord.
You should say so, no, Mr. It's not our job to plead for you and to argue for you. Not our job. You have not said that you want to file objection.
For 15, she's given January
2 weeks.
16, she has Annamalai.
My Lord, I appear for the appellant, my Lord. My Lord, I pray for 3 weeks time to comply with the office objection.
3 weeks. Yes. 16 to 23 weeks.
Bless.
16 to 21. 21. 3 weeks time is granted to comply with office objection.
Number 22, Sri Gautam Chan.
Your Lordship, serial number 19, one submission, my Lord. You have made a submission that the office has raised objection that some pages are not legible. I will not rely upon those pages at the time of hearing or admission, my Lord.
Learned counsel for the Mr. E.I. Sanmati 19. Learned counsel for the revenue submit that he shall not rely on the documents in respect of which office has raised an objection. The opposite submission is placed on record. Accordingly, the office objection is ignored. Let the appeal be listed for orders on admission.
My Lord, serial number 22, I appear for the petitioner, my Lord.
Yes.
My Lord, I have complied with the office objections, my Lord.
They still say 5 in number. So what do you?
My Lord, scrutiny slip also I have checked, my Lord, I have followed. There are certain pages that they have sketched that they have raised objection with regard to, my Lord. I'm not relying on those pages, my Lord.
Right, learned counsel for the petitioner submits that he is not placing blanks on the documents in respect of which an office, in respect of which office has taken objection. In view of the opposite submission is placed on record, the office objection is ignored.
May I please press for the interim order, my Lord? May I please go to the facts of the case?
On admission first. Let the petition listed for orders on admission day after tomorrow. Day after.
Please, my Lord. Please, my Lord.
What is day after? 4th February.
Number 23.
Much obliged.
23,
single bench.
Let the petition be listed before the approval.
23,
Yes, it has to go.
My Lord, I appear for petitioner in this case. Matter was heard before the learned single judge, my Lord. Thereafter,
we have sent it before the learned single judge only. Yes.
Number 24, Srimati Kavita Damodaran.
I appear for the petitioner, Your Lordship. Kindly grant us a week's time to comply with the office objections.
Hearing on IX, number 25.
I represent the petitioner in this matter, my Lord. This application is filed recalling the order dated 8/11/21, my Lord. As the matter was dismissed for non-prosecution, I apologize for want of prosecution on that day, my lord. As I was not keeping well, as the matter was entrusted to junior counsel, he has failed to appear. As when the matter was called, he was held up in trial court, my lord. Kindly order may be recalled, my lord.
Trial court, that's more important, right? Huh? Tomorrow you will file an application for restoration before Supreme Court, saying that counsel was busy before the trial court, right? Therefore,
Yes,
he could not appear before Supreme Court. Huh? No,
Oh, my lord,
you
I
have to
apologize for
explain.
non-appearance, my lord.
No, you have to explain your non-appearance on 21/10 also. 21st October also you did not appear.
I apologize,
Right.
my lord.
The apology won't do.
Nevertheless, my lord, there is nothing survives in the petition, my lord. This is 2018, my lord, PG admissions. My lord, admission was granted pursuant to the interim order, my lord. She was considered as a Karnataka student. She had taken a seat. Now, at this juncture, my lord, nothing survives in the petition. She would have completed the court itself.
My lord, kindly recall the order. I will address arguments on merit, my lord.
Tell us what is. We will recall provided you argue on merits.
Yes, my lord.
What is it? Page 15. Come to what is.
My lord,
No, which year you are seeking admission, Mr.
2018, my lord. My lord, she is in final year her post graduation studies, my lord. By virtue of interim order, my lord, she has secured her post graduation seat at Navodaya Institute of Medical College, Raichur, my lord. Navodaya Medical College, Raichur, my lord.
So her course must be complete, right? 2000. This is 3 years.
Yes, my lord. She is in her final year studies, my lord.
What final year? Mr. Ramesh.
Yes, my lord. Now, my lord, she has given the seat pursuant to the interim order. Now, my lord, she very well completes the course itself. Her grievance was, my lord, she was not considered as Karnataka student because she had done her MBBS, my lord, from Ukraine. So interim order was passed, my lord, to consider her as a Karnataka candidate.
Yes. Right. You are right. UK heard on IA 1 of 20. Recall is an assigned order dated so and so is recalled. Consent was granted. In this petition under Article 226 of the Constitution of India, the petitioner inter alia seeks a direction to the respondents to treat the petitioner as belonging to Karnataka state.
Yes, my lord.
Belonging to Karnataka state and to treat her candidature as candidate belonging to the resident of state of Karnataka, right?
Yes, my lord.
Yes.
Not belonging a resident of state of Karnataka, right? There also. Paragraph. A bench of this court had passed an interim order on 26/4/2018, by which it was held that the petitioner is entitled to be considered in the second round of counseling, which was scheduled to be held on 26/4/2018 under the quota belonging to the candidates belonging to the candidates who are residents of Karnataka, as well as for government quota seat as well. Full stop. Paragraph. Admittedly, in pursuance of the interim order, aforesaid interim order passed by a division bench of this court, the petitioner has been treated as a candidate belonging to the state of Karnataka and has been admitted to postgraduate course in Navodaya Medical College, Raichur, Full stop. Full stop. Since the interim order has already been given effect to, and petitioner is about to complete her postgraduate course, by influx of time, nothing survived for adjudication. In the petition, the same is accordingly disposed of.
Obliged.
Obliged.
Number 26, CH-2 Ramchandra.
My lords, I'm appearing for respondent number 1 in this matter.
Your Lordship, I'm appearing for respondent number 4.
My lords,
for respondent number 5, Your Lordship.
my lords, in this matter, we seek a week's time. We're engaging a learned senior counsel Shashikaran Shetty to argue on this matter. So we seek a week's time in this regard matter.
What is the matter about this?
My lords, the matter is
senior counsel, right?
my lords, in this matter, what has happened is that the petitioner has challenged the land grabbing tribunal's order before this honorable court, and there are various petitions.
You are for the petitioner.
My lord,
You are for the petitioner.
I am for the respondent number 1 in this matter, my lord.
Then why are you anxious? Nobody is appealing for the petitioner. Why are you anxious to seek adjournment? You have assured your friend that you will seek an adjournment on his behalf.
Not at all, my lord.
No.
I apologize for that.
So then he has not appeared. Don't worry. Pass over.
Much okay, sir.
Number 27,
Below,
Ramchandra.
the other two connected petitions have been dismissed by the Honorable Court. This petition will not survive. It may kindly be dismissed as not.
Learned counsel for the petitioner seeks leave of the court to withdraw the appeal. Withdraw the writ petition. The same is accordingly dismissed as withdrawn. Not his presence also warned back.
Number 28, Sri Vijay Kumarian. Government Advocate, Sri R. Anil Kumar, CG Networks.
For respondent number 5, Your Lordship.
Right has come. Get it.
This is
What is the special order? What is that? Art association. What association?
Art association.
So the account has been opened.
Elements I appear for the Lord Bar Council. Last
I appear for the petitioner's counsel, my lord. The first installment of 10 lakhs has been deposited. Now the second installment of 10 lakhs will have to be transferred to the fund of the clerks welfare fund.
What amount has to be transferred?
As per government order dated 4/9/2021, a sum of 4 crores has been transferred, my lord, to the Bar Council, out of which 10 lakhs has been earmarked to the registered clerks welfare fund. That 10 lakhs is yet to be transferred.
Oh, 10 lakhs has already transferred, no?
That is the first installment, my lord. And another 10 lakhs was earmarked.
by the government.
How much? 20 lakhs.
Please. During the first phase of lockdown, my lord, 10 lakhs was earmarked.
We want to understand how much is the total amount earmarked. Is it 10 lakhs or 20 lakhs?
It is totally 20 lakhs.
I have to take in 6. The other remaining amount has to be transferred. I'm taking 6 to make my submission.
Where do we get it, Mr. That this 20 lakhs has to be transferred to the council?
Lord, the Bar Council has on the last occasion made a submission, in fact, by a government order. Government order dated 4/9/2021.
4/9?
Yes,
4/9/21.
In fact, the said government order was produced by the government advocate only, my lord, on the last occasion.
Doesn't know. 4920.
Bar council has to say that, what is the amount that is balanced to be given.
No. They are pointing out from this thing. Your order, we don't know.
Now, government itself notes has deducted to an extent of 10 lakh rupees. With respect to second installment is concerned. Therefore, notes, the government notes it has to transfer with respect to 10 lakh rupees to this particular account.
The learned counsel for the petitioner submits that in view of government order dated 4/9/2021, a further amount of rupees 10 lakhs. Learned counsel for the petitioner submits that in view of government order dated 4/9/2021, an amount of rupees 10 lakhs has already been transferred in the account which has been opened in the name of Karnataka Registered Clerks Welfare Fund. It is further submitted that a further sum of rupees 10 lakhs has to be released to the aforesaid association. Full stop. In view of aforesaid submission, learned government advocate prays for and is granted a week's time.
2 weeks to take instructions.
1 week is enough. Where from you will get instructions? Bangalore only. You can reach within 1 second to heaven also. What is there? So, there's week's time to enable him to seek instructions. List immediately.
A date may kindly be given, my lord.
Immediately after 1 week, it will come up. 15th February.
Great.
Petition number 29.
My lords, in serial number 29, I appear for the appellant in OSA 3, my lords. OSA number 3 of 2020.
Yes.
My lords, I seek for an accommodation of 2 weeks. No, my lords, I seek for an accommodation of 2 weeks, my lords.
Pray for adjournment to enable him to prepare and argue the matter. Please stop for 2 weeks.
My lords, interim order may kindly be extended.
Oh, that is the problem.
But subject to
not
correction.
grant interim order you.
No, my lords.
My lords, the interim order, my lords, was passed. I appear for the respondents, my lords. The interim order was passed because there was a contempt petition pending, my lords. The contempt petition has been disposed of with liberty to revive. So there's no necessity, my lords, to extend the interim order, and subject to correction, my lords, it wasn't extended on the last date either.
Say of annexure A and B. What is A and B?
My lords, annexure A is the impugned order where the annexure, the learned single judge had the respondent herein had filed an application seeking directions against the appellant herein.
I mean, what we are trying to tell you is that please argue the matter on the next day.
Please, my lords, I'll do that, my lords.
Otherwise, we will vacate the interim order.
Please, my lords.
Interim order shall continue till next date of the
Obliged.
Shri Ramchandra Teju, here Rajendra. Number 31, Shri Siddharth Suman.
My lords, I appear for the appellant's counsel. My lord, RERA appeal, my lord, as against the order under 43(5), without giving an opportunity to deposit the amount, my lord. This is more in the nature of a mercy plea, my lord, rather than arguing on substantial questions. If my lords were to kindly see the order impugned at ink page, it starts at ink page 15. 17 is relevant, my lord. 17. Though the appellant has preferred the above appeal, as long back as 16/9 till date, he has not deposited any amount, much less the amount as contemplated or proviso to 43(5) of RERA Act while preparing the appeal. Hence, prayer is to grant some more time is rejected and appeal is dismissed. My lord, we are now ready, my lord. We were running acute financial crisis because umpteen number of cases of this nature were there. Now we are ready with money. If about 2 weeks time or 3 weeks time is concerned, we'll pay the 30%, my lord. Nobody is appearing, my lord. All are served.
My lord, I'll take notice on behalf of the Real Estate Regulatory Authority, my lord. The respondent number 3. Devaya, I.S. Devaya.
All right, so you have nothing to say. 1 and 2 are not represented.
Not represented, my lord.
Appeal has been admitted.
No, it has come up for admission, my lord.
We'll have to admit it, no, technically speaking, Mr. Suman, and then issue notice.
Then, my lord, may I seek your lordship's kind indulgence for a stay of the order of the RERA authority?
No, you serve them, we will take it up next week.
No, they are served, my lord, they are served.
See, but we can't admit the appeal today and decide it, right? Please understand, technically, they can always apply a recall saying that we did not have notice post-admission.
I leave it to your lordship. I leave it to your lordship.
That is the difficulty. Otherwise, if the appeal would have been admitted, we would have heard them, right?
I quite see what my lord said.
And if they would have appeared, then it would have been decided also.
Please, please.
Take hand summons, no, Mr. Suman.
Please.
We'll give you a date of your choice.
Please.
Heard on the non-correspondence 1 and 2, and mark the counsel for respondent number 3. Heard on the question of admission, the appeal is admitted on following substantial question of law. Whether the tribunal committed an error of law in dismissing the appeal preferred by the appellant on the ground of non-compliance with section 43 within bracket 5 of the RERA Act without affording a reasonable opportunity to the appellant. Question mark. Issue emergent notice. In addition, it will be open to learned counsel for the appellant to serve respondents 1 and 2 through hand summons. When do you want, Mr. Suman?
My lord, 10 days.
Monday?
10 days.
Whatever. 10 days is what? 14th February.
14th February, please.
My lord, if a copy of the appeal may also be submitted, furnished to me, my lord.
Please supply, Mr.
Please.
Grateful.
Next is what?
Similar, my lord, similar matter.
I represent the respondent number 1, my lords, in 32.
Yes.
My lords,
32.
this in 32, my lords.
All right, so this can be decided, right?
Please.
My lords.
32. 32. So he says that he will deposit the amount within 2 weeks.
My lords,
right?
my lords, this similar issue had already.
16 is the order. Kindly see the order in page 16.
15?
16 in page. Starts with 15.
Yes, fine. What do you say, Mr. Counsel Correspondent?
My lords, a similar issue, my lords, had the occasion to decide this issue, my lords, on 17th of November in RERA Appeal number 9 of 2021, my lords, where a similar issue was raised, whether the appellant can prosecute the appeal without depositing the pre-deposit. In light of the Apex Court decision, yes, my lords, in light of the Apex Court decision in New Tech Promoters, my lords had held this. Yes, my lords, had held it. Yes, the substantial question is similar, my lords, in this. It's at page number 14, my lords. In this appeal, it's on the similar issue, my lords. The substantial question is framed at page number 14, my lords. If my lords would just look at substantial question number 2.
RERA 9 of 21. Can you get RERA 9 of 21? No, please understand, it's not his case that he can prosecute the appeal without depositing the amount. Nobody says. Supreme Court has said it's mandatory. He's saying the only question is of reasonable opportunity. What will be reasonable opportunity in the facts? He says that 2 weeks he will deposit. He should be given. It's a right.
My lords, I bow down, my lords. My only issue is, my lords, in the appeal, they have framed the question as 30% of the amount. But the Act, my lords, refers to 30% of the amount only for the penalty, my lords. When it is with regard to refund of the amount, the total amount has to be deposited, my lords. It's not 30%.
Whatever it is, I mean, he will deposit the amount as required under proviso to this thing.
Yes, but that question may be left open, my lords, before the trial.
Yes. This appeal was admitted, no.
Not yet, not yet.
Not yet.
Heard on the question of admission. The, yes. 32. Rera appeal 18 of 21. Heard on the question of admission. The appeal is admitted on following substantial question of law. Whether the tribunal committed an error of law in dismissing the appeal referred by the appellant on the ground of non-compliance with proviso to section 43 within bracket 5 of the whole thing, right, Real Estate Regulatory Authority Act, without affording reasonable opportunity to the appellant. Question mark. With consent of the parties heard finding. In this appeal, referred under section 58 of the Real Estate Regulatory Authority, the appellant has asserted the validity of the order dated 9/11/2020 passed by the Karnataka Real Estate Appellate Tribunal, by which appeal preferred by the appellant has been dismissed on the ground of non-compliance with proviso to section 43 within bracket 5 of the Act. Giving right to filing of this appeal, it is stated that the appellant and respondent number 1 had entered into an agreement to sell and had entered into an agreement on 2/4/2013 to sell and to sell, as well as an agreement for sale of apartment measuring 1846 square feet, full stop. Sometime in the year 2019, the respondent number 1 filed a complaint before the adjudicating authority under the RERA, in which inter alia it was stated that the appellant has caused delay. Appellant has that the possession of the apartment as agreed under the agreement has been handed over belatedly to respondent. Therefore, the respondent number 1 sought the relief of refund of money along with interest as well as compensation. Full stop. The adjudicating authority passed an order dated 19/9/2019 in favor of respondent number 1. Being agreed, the appellant filed an appeal on 9/11/2020 before the tribunal. However, the appeal preferred by the appellant has been dismissed on 9th of November 2020. When did you file an appeal, Mr.?
Lord, my appeal is dated
Filed an appeal under section 44 of the Act.
26/2020.
20th June.
20th June.
20th June 2020. However, the appeal preferred by the appellant has been dismissed on 9 November 2020 for non-compliance with proviso to section 43 within bracket 5 of the Act. Paragraph. Learned counsel for the appellant submitted that the tribunal ought to have given reasonable opportunity to deposit the amount. It is further submitted that the appellant could not comply with the requirement contained in proviso to section 43 within bracket 1 of 43 within bracket 5 of the Act, as the appellant was suffering from financial crisis. It is further submitted that appellant undertakes to comply with the requirement as contained in proviso to section 43 within bracket 5 of the Act within 2 weeks from the date of receipt of copy of the order passed today. On the other hand, learned counsel for respondent submitted that sufficient opportunity has already been granted to the appellant to deposit the amount. Paragraph, we have considered the submissions made on both sides. In view of the stand taken by the appellant hearing that he is prepared to comply with the requirement contained in proviso to section 43 within bracket 5 of the Act, within a period of 2 weeks from the date of receipt of copy of the order, and in the peculiar facts of the case, we answer the substantial question of law in the affirmative and in favor of the appellant. The impugned, therefore, the impugned order dated 9th of November 2020 is hereby quashed and set aside. The needless to state that the appellant shall comply with the requirement of deposit of the amount as contained in proviso to section 43 within bracket 5 of the Act within a period of 2 weeks from the date of receipt of copy of the order. On such deposit being made, the tribunal shall proceed to deal with the appeal filed by the appellant in accordance with law.
May I make one submission, Malod? Malod, during the narration, Malod, also narrate.
Just aforesaid with the aforesaid direction, the appeal is disposed of. Yes.
Malod's narrated that the apartment has been handed over. Malod's, the apartment has not been handed over, Malod's. We have sought for cancellation. When all contentions may be left open, Malod's, before the tribunal.
Of course. With aforesaid direction, all contentions are kept open. Then say possession was not handed. Possession of the apartment was not handed. Therefore, fine.
Grateful, Malod.
Please, Malod. Oblige.
Your Lordship, I appear for appellant, my lord. Your Lordship, the appeal filed by the revenue, my lord, the questions of law are at page number 4, my lord. The tribunal has set aside the addition made under section 32 as well as section 36(1)(3), my lord, on the ground that the building assessee is entitled for depreciation on this building, my lord, which was not ready for occupancy, my lord. Question number 1 and 3 requires consideration, my lord. Section 32 as well as section 36(1)(3).
Heard on the 1 and 3 notice.
Much obliged, my lord.
Number 34, the KV Arvind.
That's 34 and 35, my lord, this pertains to the royalty, my lord, which your lordship said deferred it, my lord, by 2 weeks, my lord, awaiting outcome of that.
Revenue submits that against the issue was that the issue involved in this appeal is pending adjudication in a review proceeding before the Supreme Court. He therefore requests for adjournment. This after 2 weeks.
Please.
34, 35.
36.
The 36, my lord, the assessee, my lord, is educational trust, my lord, running medical college. My lord, search was conducted. My lord, huge the violations of, my lord, the collection of capitation fee and, my lord, not being accounted, my lord, was found. And hence, my lord, to that extent, my lord, the deduction, my lord, under 11 was denied. That is one first question. Second question, my lord, the cross-examination, my lord, of various persons, my lord, where capitation fee, my lord, was paid, my lord, that was recorded and that was provided, my lord, because the assessee, my lord, has not, my lord, the cross-examination was not provided. On that ground, my lord, it has been set aside. Third issue, my lord, is on whether, my lord, the search assessment, my lord, is exclusively on the basis of seized material or not. In fact, my lord, 3 has been answered, my lord, by the coordinate bench recently, my lord, after filing of this appeal in the month of December, my lord, in favor of the revenue, my lord. And are also, my lord, the consequential, my lord, the questions, my lord, all 7 questions, my lord, all 7, my lord, are on independent aspects, my lord. Overlapping, there is no overlapping in this case, my lord. All 7 on different aspects, my lord.
Oh. The thing, 1 and 5, same thing.
Well, 5 speaks about the depreciation, my lord. Whether the trust is entitled for depreciation, because application, my lord, has already been allowed as a depreciation. Please, my lords.
In D group. Number 37, Sri M.V. Sundararaman, Sri T.V. Chandrasekhar.
My lord,
Sri
I appear
T.V.
for the
Sudhi.
petitioner in serial number 37, my lord.
I'm respondent.
My lord, the senior counsel engaged in this matter is currently recovering from COVID. He is unwell. We request 2 weeks time, my lord, to be allowed to be heard in this matter.
Counsel for the petitioner submits that the arguing counsel has suffered from COVID and is in the process of recovery. He therefore pays for examination. The process is
38.
Obliged, my lord.
49.
My lord, appearing for the petitioner, my lord.
But
appear for respondent, my lord. The order, my lord, which is under challenge is the order of the State Commission under the Consumer Dispute Redressal Act, my lord, allowing an appeal despite the objection raised by the railways that the Railway Claims Tribunal has the absolute authority. The State Commission, my lord, has relied on one unreported judgment of this court. I have a copy of it, my lord. I'll have to produce it, my lord. On Tuesday, my lord. I'll file it along with a memo before my lords.
Counsel for the petitioner for short adjournment in order to enable him to do a copy of the order on which
Passed in WP number 25096, my lord.
Copy of the order dated.
The order dated 8th September 2010.
8 September 2010, passed in WP number
25096 of 2010.
Just on Tuesday.
Great.
39, C.N. Nagarajappa, Government Advocate, Sri Gopal Krishna Sudhi.
Shall appear for the petitioner, Your Lordship. Request for a week's time, Your Lordship.
Winter vacation is over. You are still in vacation mode. Huh? What? Why it should be adjourned, tell us? It is such a difficult question, Mr.
Please, Your Lordship.
No, we ask you why it should be adjourned.
Your Lordship, the senior is engaged in another case, Your Lordship. That is the reason.
No, but you are a senior for this court. You are appearing. We treat you as senior counsel under Section 16 of Advocates Act.
Your Lordship, kindly pass over, Your Lordship. Your Lordship, kindly pass over, Your Lordship. I will argue.
Who is the comment?
Sri Gopal Krishna Sudhi,
Huh?
Government Advocate.
Human Rights Commission. All right, pass over. Let's see if he appears.
Please, Your Lordship, I will argue.
Yes, sir.
The party, Sri Nanjare DPN, Government Advocate, Sri A.V. Srihari.
Appearing for A.V. Srihari, madam. R3 to R5, madam.
Appears for petition. What is it?
Sri Nanjare DPN.
Where? They are not there. Pass over them.
Number 41, Sri A. Ravi Shankar, Government Advocate.
Appear for appellant, my lords. Petitioner, my lords. I seek a week's accommodation, my lords. Senior is not. I seek a week.
Senior appeared before this court yesterday only and argued.
Please, my lords. Please, my lords. Please, my lords. Not there today, my lords. That's why I humble request, my lords. Next week.
You are there, right, to argue the case. Huh?
He had taken the file, my lords. He could not come, my lords. That's why. He has taken the. He had to leave for some emergency, my lords. That's why he's not there. The file is with him, my lords. We will also prepare a synopsis and file, my lords.
This is the new argument, madam, I have heard in during my stay over a period of 3 years. Maybe you should give this input to the book which is being written on law of adjournments. That senior has gone out, he has taken the file with him.
Well,
So,
yesterday night he had taken the file to.
No. So therefore the court can't even ask for whom you are appearing. Right?
No,
Very good. Very good. No, very good. Very good, madam.
Sorry, my lords.
I'm sure that people must be watching you and they will learn that this also can be said.
No, my lords, I submitted the facts, my lords. Yesterday night he took the file, my lords. He could. My lords.
This afternoon.
Interim order may kindly be extended.
That's the problem. The moment we will not, this thing you will appear and be ready with the case.
So one week, next week we will advance.
The model will continue till next day.
Much obliged.
42, Sri D.S. Gautam.
Lord, serial number 42, I am appearing for the petitions council in this matter, Lords.
I appear for the sixth respondent, Lordship.
I appear for respondent number 2.
And what about 5 and 4 and 5?
Sri Ashok K. Nayak, Sri Prakash K.M.
Lords, 4 and 5 will be formal parties, my lords. For the purpose of disposal, the order under challenge is the order passed by the second respondent.
My lords, that may not be correct, my lords, because respondent number 4 will also have to defend, my lords, because they have extended the date for admission unilaterally, my lords, in disregard of the Supreme Court's order, my lords.
I will be in a position to demonstrate that there is, so far as the petitions are concerned, notwithstanding the extension of time, we were given the admissions on 7/10, which was the last date itself. Kindly take, my lords, Annexure A, page number 18.
Mr. Ravi Shankar, please wait for 5 minutes. We'll pass it over. Then
Very
we
well.
will say that pass over round also nobody has appeared, so we can go ahead.
Very well, my lords, very well.
Yes.
43, Sri D.R. Nishchal Dev, Sri N.K. Ramesh, Government
My lord,
Advocate.
I appear for the petitioners in this matter, my lord. I seek for a week's accommodation, your lordships. Certain people in our office have tested positive for COVID. Moreover, your lordships have engaged.
Tested positive, right?
No, your lordships. However, we were not able to access the files. Moreover, your lordships, we are led by senior counsel Mr. K.G. Raghavan. We're not able to brief him also. It may be taken up next week, your lordship.
Counsel for the petitioner pays for adjournment.
My lord, there's also an interim order.
No, this all, I mean, because of interim order only, Mr. Counsel.
Of course not, your lordship. I apologize, but maybe taken up.
All, what? Why you should not prepare an argument? What is this? Praise for adjournment on the ground that the matter has to be argued by K.G. Raghavan, learned senior counsel who is not appear. This next week. Interim order. If any can continue till next date of it.
Much obliged.
44, Sri Vivek Honda.
Lord, I appear for the
I appear for the respondent in this case, madam.
Lord, can I seek for a passover, my lord? That list of dates, I'll send it across to your lordship's court. If your lordship just pass it over, my lord, I'll.
Yes, madam, you are ready.
I'm ready.
I have sent it to my lord her, but I'll, my lord, I'll give the physical copy across to your lordship's court. No?
Yes.
Yes.
45, Sri Shirvan Vijay Kumar Maheshwarappa.
45, I'm appearing for respondent number 1, please, my lords.
Appearing for respondent number 3.
Appearing for respondent number 5.
For respondent number 3.
Nobody appears for the petitioner. Let's see.
Passover matters. Number 26. H.V. Ramchandra Rao, Sri Shahbaz Hussain, Sri S.R. Anuradha.
Not for the petitioner, even when give the file. None for the petitioner even when matter is called in second. None for the parties even when matter is called in second order.
Your Lordship, for the respondent number 4, Your Lordship.
Respondent number 4, right? Then
Yes,
I'm
Your
appearing in behalf of respondent number 1.
37/2018 also, none had appeared on behalf of the petitioner. It appears that petitioner is not interested in prosecuting the writ petition. The same is dismissed.
Number 30,
Much obliged, my lord.
Much obliged, Your Lordship.
number 30, Sri Ramachandra Desu, Sri K.R. Rajendra, Nagesh Pujari.
Take anybody appear?
Directed to this matter along with the connected.
For the appellant even when matter is called in second. Not interested, dismissed.
Number 39, Sri Nagarajappa A, Sri Gopakrishna Sudi,
Where? 39. He is not there. Mr. Nagaraj.
That's why I appear for the petition.
Petitioner, we will fix it. Mr. Government Advocate for 1 and 2. None.
That's why I appear for the petitioner in this case.
None for respondent number 3. Even when the matter is called in second round. Awaiting appearance of learned counsel for respondent number 3. Hearing of the petition is deferred. It is made clear that in case no appearance is made on the next date of hearing, appropriate order shall be passed. List on 8th of February. 8th February, Mr.
Please.
number 40, Sri Nanjareddy T.N., Sri Srihari A.V., Government Advocate.
What is this last date?
Government advocate was directed to take notice.
Not for petitioner. Only in second round. Government Advocate for 1 and 2 appears not interested. Dismissed from
Number 42, Sri D.S. Gautam, Government Advocate, Sri D.S.
I appear for the respondent number 6, Lordship.
Appearing for the respondent number 4 and 5.
Lordship. Yes, where is Mr. Ravi Shankar?
Sri D.S. Gautam,
My lord, senior relative is expired, Your Honor. Kindly have it on tomorrow, my lordship. Respondent
What's your
number
name?
4 and 5.
What's your name?
Manjunath, my lord.
You not learned counsel correspond number 4 and submit 4 and 5 submit that what that arguing counsel. Mr. Ravi Shankar, the counsel for 4 and 5 has suffered a bereavement in the family. Some relative has expired.
It can be adjourned to any date of their convenience.
So when do you want this, sir? Day after?
The day after tomorrow, Your Lords.
Arguing counsel, Mr. What's the name of your senior?
K.M. Prakash, my lord.
K.M. Prakash has suffered a bereavement in the family. He therefore prays for adjournment. Suffered a bereavement. He therefore prays for adjournment. List day after is 4th February 2020.
Please.
Great. Much obliged.
44, Sri Vivek Kolla, Srimati Shweta Anand.
I appear for.
Yes.
Yes, no, it was passed.
Passed. You have
It
got
may kindly
this,
be taken on Monday or Tuesday, my lord, so that let them place whatever they want finally.
No, finally, you have got the copy, right? Madam?
44. No, I don't want anything because I have my books. I will submit on based on the facts itself.
No, Mr. Kolla told us that he served the copy to you probably.
Passed over, he asked, and second came over. He asked for a password.
Yes, please.
Senior counsel asked for a password.
He is there. 44.
Lord, I'm sorry.
Yes.
Lord, that list of dates, my colleague, Lord, junior has, I don't know whether, Lord, it has come there. Otherwise, Lord, I'll start.
He has not come.
Oh, I'm so sorry, Lord. Just now, Lord, he left. Okay. Lord, in this, here, Lord, the petitioner, Lord, is engaged in the business of providing, Lord, security guards to various industries. They have about 1,000, sorry. They have about 1,000 employees working, Lord, for them on their roads. Lord, when they provide security services, they'll have to receive monies, Lord, from the persons, Lord, to whom they, Lord, give the security services. Like, Lord, in an apartment, Lord, or in a business, Lord, commercial business premises, commercial premises. They provide, Lord, the security services. Lord, there will be, Lord, guards who will be, Lord, there, or, Lord, watchmen, all that kind of a thing. They have been, Lord, diligent in paying. For a little while, Lord, there was some, Lord, we did not receive monies, and therefore, Lord, the Provident Fund, Lord, was not paid.
What period?
Ultimately, Lord, we paid it. There was a delay. There was, Lord, no laxity in payment. There was a delay because, Lord, the employers, Lord, whom, Lord, we had provided the services did not pay, and then therefore, Lord, there was some, Lord, delay.
For which period we asked? Period.
They issued a show cause notice, Lord, on 16/12/2013.
Yes.
Annexure A, Lord, page 21 is, Lord, the show cause notice. This is, Lord, page 21. Your Lords get that, Lord. And, Lord, they say that, Lord, these are the amounts, Lord, which are required to be paid. Lord, if your Lord just look at, Lord, the delays, my Lords may turn to, Lord, page 23. 2-3. Column number 3, my Lord, has, my Lord, the number of days, my Lord, delay. It is not that, my Lord, it was, my Lord, for years. 9 days, my Lord sees, my Lord, column number 3. First one, my Lord, 9 days. Second one, 10 days. 22 days. 23 days. My Lord, it goes on like that. 6 days at the bottom. Next page. A few days delay has, my Lord, occurred. We are not denying or disputing it. But then all of them are very minimal. A few days. But we paid them, my Lord. Sorry.
Page 23. Where is it? Here is the division. Yes.
Then, my Lord, we filed, my Lord, our detailed objections. My Lords get that at page 49 and 52.
Two.
49, my Lord, is 1, annexure B. And, my Lord, 52 also. 2, my Lord, replies we sent. The commissioner, my lord, has now imposed, my lord, penalty of 79 lakhs. My lord, annexure D, page 55, your lords get that. Please come to my lord 58, 58. My lords get the amount, my lord, that he has imposed. In the middle, my lords, your lords get that. For, my lord, the interest portion, he passes another award, my lord, another order. My lords get that at page 68, my lord, annexure E. Sorry, my lord. My apologies. Annexure E, page 68. Your lords get, my lord, the subject. Sorry, 68, subject. Interest payable under section 7Q of the Employees Provident and Miscellaneous Provisions Act. Page 72, my lord, your lords get the amount. 41 crores, sorry. 41 lakhs, 40,013.
Yes.
This interest will not be paid. This 41 lakhs we paid. What we are challenging, my lord, is the order, my lord, at page 58, where, my lord, the penalty, my lord, of 79 lakhs, 29,768 is imposed. We filed an sorry. We filed an appeal, my lord, before the tribunal. My lords get that at, my lord, page 96. Sorry, this is attachment order.
It is order of act.
My lord, I'm sorry. I own apology, my lord. My lord, 101, sorry. 101. Sorry. Annexure H, page 101.
Yes.
The appellate court, my lord, the tribunal, my lord, rejects my appeal and, my lord, confirms the order. Order, my lords, get that at page 134, my lord. The actual order, 134, annexure M. In fact, my lord, what had happened was, even before that time, my lord, for appeal, my lord, expired, they had, my lord, issued an attachment order. We challenged it before your lordships. Your lordships, my lord, directed that, my lord, order, your lordships get that at page 129, my lord. 129, where, my lord, your lordships granted an interim order. And, my lord, in so far as that penalty is concerned, because interest we paid, my lord, 41 lakhs. Your lordships, my lord, granted an interim order and said, my lord, that the appeal be disposed of within a specified period. That is when, my lord, page 134, the appeal, my lord, is dismissed. My lords, I wonder, my lord, whether your lordships got the list of dates. My lord, all those, my lord, we have put it there, my lord, for my lord's consideration.
Yeah, we have got it.
Very well, my lord. I'm sorry, my lord, what happened was, immediately I told your lordships to, my lord, seek a pass, sort a pass over, my lord, I sent it. Traffic was, my lord, one. Sorry, my lord. My lord, we are challenging, my lord, this order on the ground, my lord, that penalty, my lord, can't be, my lord, imposed for the asking (14B), my lord, of the Provident Fund and Miscellaneous Provisions Act of 1952. My lord, it specifies, sorry, it reads thus: 14 capital B, my lord. Where an employer makes default in payment of any contribution to the fund, pension fund, insurance fund, or in the transfer of accumulations required to be transferred by him under subsection 2 of section 15 or subsection 5 of section 17, or in the payment of any charges payable under any of the provisions of this act or of any scheme, etc., my lord. Government, my lord, by notification of the official gazette, may recover from the employee by way of penalty such damages not exceeding the amount of arrears as may be specified in the scheme. My lord, I have given, my lord, some judgment for my lord's consideration, my lord, where this, my lord, the Honorable Supreme Court, as well as this Honorable Court, held, my lord, that in the instant case, my lord, if your lordships, my lord, your lordships have seen, the show cause notice is issued in the year 2013.
Yes.
My lord, if your lordships come to, my lord, page, just, my lord, for the only one page I will show to your lordships. Page, my lord, 23. 21, my lord, if you page 21, that first show cause notice.
Yes.
My lords may come to, my lord, there's a tabular column. Below that, now the scrutiny of records maintained by this office for the remittance made during the period 1496 to 16 to 2013. So, my lord, they are seeking to impose penalty for the period, my lord, which is from 96. That is, my lord, if it is 96, 17 years or over. 97, my lord, it will be, my lord, 16 years. So, my lord, it will go on like that. This Honorable Court, my lord, has held unexplained delay, my lord, first judgment, if your lordships take, my lord, ILR 2014, Karnataka, 1223.
Yes.
Paragraph, my lord, 10. Para 12, my lord, your lords may take, my lord. I will not trouble your lords with para 10. There, my lord, again, there is a delay of, my lord, running, my lord, like here, from, my lord, 5 to 20 years. Para 12, in the facts and circumstances, my lord, based on a judgment of the Honorable Apex Court. Para 11, my lord, can I be permitted to read, my lord, for a...
Yes.
In Hindustan Times versus Union of India, at paragraph 29, Apex Court opined that it is possible for the employer to claim the benefit of irretrievable prejudice in case of demand for damages made after several years. It is also stated there are Ketina of decisions Apex Court on the point that if a statute of, if in a statute, the period of limitation is not fixed or doing a particular act, in that event, action should be initiated within a reasonable time. What is reasonable time, it is said, depends upon the facts and circumstances of each case. In the facts and circumstances of this case, there being no plausible explanation for the inordinate delay in initiating proceedings under section 14B of the Act, appellate tribunal justifiably held that the petitioner failed to invoke section 14B of the Act at the earliest to levy and recovery of damages. In the instant case, my lord, the tribunal does not appreciate, my lord, this judgment. Second judgment, my lord, is page 13, 1-3. My lord, this is a well-known concept. Power, my lord, has to be exercised within a reasonable time, failing which, my lord, the courts will frown upon it. This was a case, my lord, where after 1 year, my lord, suo motu proceedings were initiated. Paragraph 2, my lord, their lordships, my lord, hold that the power has to be exercised within a reasonable time, my lord. That's, my lord, a well-known concept. I'm sure, my lord, your lordships also would have held, my lord, similarly. Sorry.
Yes.
Lord,
We have.
Third judgment, my lord, is page 16, my lord, 1-6. Mere proof of default, my lord, does not attract penalty.
Yes.
Can I persuade your lordships, my lord, just to turn to paragraph 8 of that judgment at page 16? At 19, my lord, it starts at 16. At 19. That was no doubt, my lord, not under the Provident Fund Act, but under the Sales Tax Act, my lord. Sales Tax Act. But then, my lord, the reasoning will apply even here. Under the Act, my lord, paragraph 8. Under the Act, penalty may be imposed for failure to register as a dealer. Section 9(1) read with Section 25(1) near the Act. But the liability to pay penalty does not arise merely upon proof of default in registering as a dealer. An order imposing penalty for failure to carry out a statutory obligation as a result of quasi-criminal proceedings, and penalty will not ordinarily be imposed unless penalty oblige either the act party obliged either acted deliberately in defiance of law, or was guilty of conduct contumacious or dishonest, or acted in conscious disregard of its obligations. Penalty will also not be imposed merely because it is lawful to do so. Whether the penalty should be imposed for failure to perform a statutory obligation is a matter of discretion of the authority to be exercised judicially and on consideration of all relevant circumstances. Even if a minimum penalty is prescribed, authority competent to impose the penalty will be justified in refusing to impose the penalty when there is a technical or venial breach of the provisions of the Act, or where the breach flows from a bona fide belief that the offender is not liable to act, etc. My lord, here it is my specific case. My employers did not pay. My lord, after all, my lord, 1,000 people are there. There are delays, my lord, of running, my lord, 6 days, 10 days, 12 days. In fact, my lord, page 74 of my petition, if your lordships take my sundry debtors, 74 to 95, I have set out, my lord, the monies that are owed to me in respect of all these, my lord, 74 onwards, it runs up to, my lord, 95. My lord, the next judgment, my lord, at page 23, my lord, it is under the Provident Fund Act itself. Paragraph 3, my lord, of this judgment, if your lordships permit me to read, my lord, at page Manu K 0278 1991. Nalakneddu. Kottilla tamige. I'm so sorry. My apologies.
No worry.
My apologies. So sorry. I thought, they had sent it. I'm so sorry. Email kalsidarante nodi. Just check up. Otherwise, I'll again ask them to resend.
No problem. I'll just.
So sorry. My lord, please come to my lord, paragraph 3. There can be no doubt, page 24, that the levy under section 14B is predominantly a penal levy imposed by the commissioner depending upon the circumstances of each case. There's no compulsion that in each and every case of default, there should be a levy under section 14B, and the judicial discretion has to be conferred on the statutory authority. My lord, last but one, please come to, my lord, running page, my lord, 25. Paragraph 18 and 19, my lord. '47, my lord. My lords get that at page 47. Starts at 25. My lord, the judgment of Hindustan Steel is referred to, my lord, in paragraph 17 on the previous page. Paragraph 18, my lord, relying on that, applying the very same principles to the provisions of the EPF Act, section 14B and para 32A and B of EPF scheme, it cannot be but construed as being directory and not mandatory, while the levy of damages by a penalty is discretionary and not imperative in all situations. And the use of the words may recover in section 14B, legislature having limited jurisdiction to levy damages not exceeding the arrears, said section must be construed regard being had to the language deployed and not dehorse the same. Paragraph 32A and B cannot have overriding effect on section 14B, the legislative provision. In the view taken by the apex court in HMT's case supra, existence of mens rea or actus reus to contravene section 14B must be held to be a necessary ingredient to levy damages or the quantum thereof. In the instant case, my lord, I pointed out, my lord, over nearly 2 crores of rupees, my lord, are owed to me. There were delays of 6 days, 10 days, 12 days. Next para, my lord, if your lordship take, my lord, para 19 in the same page, page 47, my lord. There is no doubt that paragraph 32A and B of the scheme, EPF scheme, prescribe general guidelines over the limits to which the imposition of damages is permissible, and mitigating circumstances can be taken into consideration by the adjudicating authority in fully deciding the quantum of damages, and is not bound to mechanically apply the uppermost or the lowermost table as the limit. It is submitted the appellate authority has in many an appeal restricted the damages to 15% of the arrears of contribution to meet the ends of justice, which consideration is not forthcoming from the order impugned. Same thing here, my lord. Whatever, my lord, they had in terms of 32AB, they, my lord, imposed the whole of it. Then, my lord, the next judgment is page 49. Right. Same thing. My lord, it's similar, my lord. I don't think, my lord, I should replicate, my lord, judgment. The other two, my lord, are similar, where this honorable court, my lord, has consistently taken the view, based on HMT's case, that merely because penalty is, my lord, provided, you can't impose it. And, my lord, you must take into account, my lord, the considerations, whether, my lord, there's mens rea, all that. In the instant case, my lord, I have submitted, I produced, my lord, all the, my lord, material to show that, my lord, I have been, my lord, consistently paying, my lord, I have never defaulted. There were some delays because, my lord, the money is recoverable, my lord, was delayed. And, my lord, that therefore, my lord, the imposition of, my lord, that penalty, the whole of it, my lord, is illegal. That's all, my lord. I don't think, my lord, I should trouble your lordships anymore.
Yes, yes, madam.
With your lordship's kindly. My lord, so far as the facts are not disputed, so I'm not going on to the facts, except the law on the issues. So far as section 14B and 5 and 32A, your lordship may kindly read once again 14B of the Act statute, where the power to recover damages for the belated payments. (14B), the senior counsel has read the first part of the 14B.
Yes, madam.
Well, so far as this is concerned, where an employer makes default in the payment of any contribution to the funds, these are under any of the conditions specified under section 17 by notification delay in this way may recover, very next page, may recover from the employer by way of penalty such damages not exceeding the amount of arrears as may be specified in the scheme, provided that before levying and recovering such damages, the employer shall be given a reasonable opportunity of being heard. Provided further that the central board may reduce or waive the damages levied under this section in relation to an establishment which is a sick industrial company and in respect of which scheme for rehabilitation has been sanctioned by the Industrial Companies Special Provisions Act 1985, subject to such terms and conditions as may be specified in the scheme. So, my lord, with this, I do not have powers under that. The officer who has conducted an inquiry does not have any powers either to reduce or waive because of the sympathy factor. What is sympathy factor in this case? As the learned senior counsel has submitted, there was a delay in collecting the funds from his employees, the security contractors. So that should not be a reason for non-remittance of the employer's contribution towards the EF, because the Employees Provident Fund is a social legislative piece of legislation. It protects the interest of the workman only when the employer and the employee pays or remit the contribution within 15th of the preceding very next month. So when such being the case, levying 14B, levying damages under 14B cannot be fine fault is my humble submission. Then second thing is, well, even the statutes has provided the method of levying the penalty. How to levy the penalty also. Your lordship may kindly turn to para 6, para 4, my lord. At para 6, my lord. 4, 5. Para 4 and 5 of the employer's scheme. Para. The employer shall pay para 4 and 5.
Of what?
Of the same scheme, pension scheme. I'll take your lordships to mode of payment of contributions. First, I'll take your lordships to 38 Mala. How he has to pay the contribution to the EPF. Employees Provident Fund Scheme 1952 schemes.
Yes.
Lordship will get it. How he has to pay. The employer shall, before paying the member his wages in respect of any period or part of period for which contribution are payable, deduct the employees.
What are you reading?
Because he has already deducted. He has already deducted his contribution. The employee's contribution.
Reading, we don't get it.
No, what is that you are reading? We are unable to get it.
I am 38 mode of contributions at the Employees Provident Fund Scheme 19.
Section 38 or what?
That is a scheme. 38.
Scheme is it? Okay.
Yes.
Para 38.
Yes, Your Lordship.
Ah.
So here it says mode of payment of contributions. So here it says the employer shall, before paying the member his wages in respect of any period or part of period for which contribution are payable, deduct the employee's contribution from his wages, which together with his own contribution, as well as an administrative charge of such percentage of the basic wages, dearness allowance, if any, and cash value of food, so and so, the time being payable to the employees other than and so and so, shall within 15 days of the close of every month pay the same to the fund through electronic or internet government. So, my lord, it is very clear. Before paying the contribution towards the employees and payment of contribution to the Employees Provident Scheme, he has already deducted. Once he has deducted, that means the fund of the employees lies with the employer. He cannot utilize it. That is why the damage and then penalty has come. If at all he has to pay the amount, then he has to deduct from his contribution and read from the contribution of the employees and pay it within 15th of the month. When he has paid it, that means the fund lies with the employer, hence the damages and the penalty are leviable. This is my humble submission. Then, my lord, how we have to recover damages for default in payment, how it has to be calculated is also given in the statute. That is at para 32A of the same parasol. 32A, if at all the employer fails to pay the contribution, then where an employer makes, did your lordships get it?
Yes.
Sorry, madam. Where an employer makes default in the payment of any contribution to the fund or in the transfer of accumulations required to be transferred by him under subsection 2 of section 15 or subsection 517. In the payment of any charges payable under any other provisions of the Act or the scheme or under any of the conditions specified under section 17 of that, the Central Provident Fund Commissioner or such officer, as may be authorized by the central government by notification so and so, may recover from the employer by way of penalty damages as the rates given below. So only in accordance with this table, following the officer, the recovery officer has passed an order. It is not that it has an exorbitant. When the amount was lying with you, since if at all any delay, the delay it does not come in the way of levying penalty because of the reason that the Provident Fund will accumulate and take contribution from others and will be depositing in the employer's contribution. As and when the employer's pays, it will be remitted into the account, that's all. But the employees of Provident Fund cannot stop payment of a retired employee's Provident Fund because of default on the employer. Many persons might have retired at that time. So at that time also, Provident Fund has given them all the benefit, extended all the benefits, despite their being default or belated payment by the employer. Now, your lordship may kindly see the Times of India, that is the Hindustan Times Limited, wherein the senior counsel has delayed only for the purpose of not delay and also when it can be reduced. Your lordship may see that is Hindustan Times, the senior counsel has given. Relevant paras, I will take your lordships to here. The delay has been exorbitantly considered here. And then 15, your lordship may kindly 15.
Hindustan Steel, not Hindustan Times.
Yes, please,
Hindustan Steel you are referring to?
Yes, Hindustan Steel.
Okay,
that has been furnished by the senior.
You said Hindustan Times, so we got confused.
Oh, I'm sorry. One more judgment is this. I'm sorry.
Yes, 16.
I'm sorry. Well, 15 para may kind mention. From I read several paragraphs in this. So, in commission 15.
Relying upon.
Yes, same judgment. In Commissioner of Coal Mines Provident Fund, so and so, interpreting section 10 of this own so. It was stated by this court that by use of the words may levy damages, 15 in Supreme Court cases, Hindustan Times Limited versus Union of India and others.
No, this is not Hindustan Times. It is Hindustan Steel, madam. Again, we are telling you.
Oh.
Not Hindustan. We don't have Hindustan Times.
Oh, I'm sorry, my lord. It is reported in 1998, Part 2, SCC 242.
98 volume 2 SCC?
1998 part 2 SCC 242.
242. It's not probably with us. Where is the book? Go ahead, madam.
Well, so far as this judgment is concerned, it says that it was stated by this court that by the use of the words may levy damages, in case of default in payment of contribution, and the words as it may think fit to impose, it was clear that the determination was not based on the inflexible application of a rigid formula, and that by these words the authorities were to apply their mind of the facts and circumstances. As a duty was a judiciary imposed on the authority, principles of natural justice was implied. In organochemical industries versus Union of India, where the words of the act were upheld, this court laid down that while passing orders under section 14B, the authority was acting in a quasi-judicial capacity and was bound to give reasons for its orders, what may unfriended. The levy was not necessarily proportionate to the loss incurred by the employee in as much as it was partly compensatory and partly penal. So this I wanted to bring it to your lordship. Then, my lord, did your lordship speak with judgment?
Get it. Yes.
Judgment. I am sorry, my lord, without judgment.
It's a quasi-judicial power. Authority is required to assign reasons.
Yes,
How does it help you?
No, there are several principles has been laid down in this case, my lord.
And they say there is no limitation. Para 7-8 is the reason. That is reposition paper 136 and 137. Do refer to this case so far as limitation is concerned. No limitation. Yeah.
Yes, madam.
So, my lord, what my submission before your lordship is, because when it is an admitted fact on record that there was a delay in payment of contributions towards the employees' provident fund, when levy of damages has been statutated and it has been passed in accordance with the statute after extending the opportunities to the employer, they cannot have anything because we have not charged, overcharged or charged less. And so far as the limitation is concerned, my lord, it is a continuing cause of action. There is no question of limitation comes in between. Because of the reason, he has already collected. He has already utilized this. When he has collected and
limitation. Not a question of limitation, but that means that you can invoke the power you want to contend under section 14B even after 50 years because it's a continuing cause of action, right?
My lord, it is not so. It is not so. A reasonable time is.
As a proposition.
Please.
In this case, you have invoked after 17 years, and if the law according to you, law permits you to invoke even after 50 years because it's a continuing cause of action.
No, it's not only that, it is very well within his knowledge.
So what happens to? Please tell us a good reason why for a period from 96 onwards you did not take action within reasonable time, say 3 years, 4 years or 5 years, let's assume 10 years. Why did you invoke it after 17 years? What is the justification? Any explanation from anywhere?
Lord, when default has come to the notice letters, then immediately action has been initiated.
Default was committed in 96, madam. Do you want to say that 96 default was not within your notice?
Lord, your lordship may kindly turn to the order.
No. Is there a finding that it has come to notice on this particular date?
My lord, it has been levied only for that particular period, my lord. Your lordship may kindly turn to Annexure D. Annexure D may kindly be seen. Produced along with the writ petition, Annexure D order 24 to 2015.
Yep. 13 years. Yes. 10 years.
My lord, 24, your lordship may kindly turn to Annexure D 24 to 2015 order.
Yes.
My lord, your lordship may kindly see at page number 55, the front page. Then page number 56, your lordship. The Scorpion Security Limited had failed to pay the following dues within the stipulated time as provided for under para 38 of the Employees Provident Fund Scheme 1952 and para 8 of the so-and-so. Contribution for the period of March 2003 to 2013 onwards. for the period 2003 to 13 onwards. So it was just 2003, my lord, not 1996 or 97.
Oh, just 12 years. It's a reasonable time according to you.
My lord, it's because the moment it comes to the knowledge that there is a delay in refund of.
This is your argument, madam. Where do we get it? Is there anything that it came to the notice in the month of February 2015? All right. Please go ahead in your own way. What else, madam? Anything else?
So that is what we have recited here, that because there is no time limitation for charging the. Yes.
That
In this order, it has been clearly mentioned, even including the delay also, it has been answered by the recovery officer. They say that they did not say anything before the inquiry officer. Your Lordship may kindly, I have gone through the facts of the details of delays in remittance and submissions made by the establishment. Page 3 in 57. 57, Your Lordship may kindly see. So far as the issue of financial difficulties is concerned, they said only this. Is issue already settled by the Supreme Court of India in the case of Hindustan Times versus Union of India, 1998, Part 2, SCC 24, where the Honorable Court says the default on the part of employer based on a plea of power cut, financial problems relating to other indebtedness, or the delay in realization of amounts paid by the checks or drafts cannot be justifiable grounds for the employer to escape liability. In other words, it is already settled by the apex court level. The financial problems is not mitigating factor in levy of damages. Then further, Honorable Supreme Court has summarized the following principles regarding levy of penal damages and interest. Same case, the authority under section 14B has to apply its mind to the facts of the case, that what I read, and they reply to show cause notice and pass a reasoned order after following principles of natural justice and giving a reasonable opportunity of being heard. The Regional Provident Fund Commissioner usually takes into consideration the number of defaults, the period of delays, the frequency of the cut for financial problems, and the amounts involved. Default on the part of the employer based on pleas of power cut, financial problems relating to other indebtedness of the delay in realization of amount paid by the checks or drafts cannot be justifiable.
That's all right, madam. That's all right.
Please
just tell us one this thing. How this figure of 79,29,768 has been arrived at? Any reasoning?
Well, that has been calculated in accordance with the statute itself, because the statute prescribes for the levy of damages for 10 days, 15 days, 20 days, grace period of 5 days.
In accordance with, according to you, para 32 or 38 of this.
Please, my lord. Please, my lord.
All right.
Please, my lord.
Yes. So you should say so.
Because 32A and 8A.
This is all you are supplementing the order by assigning reasons. Fine. What else?
This is what I have been instructed to submit.
Thank you. Yes, Mr. Hulla, anything?
I want to place before your lordships. One is that HMT, my lord, that Hindustan Times case has been considered, taken into account, my lord, by this honorable court. Please come to, my lord, running page 55. 55.
Yes.
That is, my lord, the judgment under, my lord, the act itself relating to, my lord, the imposition of penalty. Please come to 62. Sorry, my lord, the first one, in the first judgment, my lords get that at page 8. Page 8, paragraph 11. In the second judgment, my lord, the fourth judgment, page 63, my lord, not 62, paragraph 19. Para 19, my lord, in the third judgment, 55, Justice Subhas Adi's judgment, my lord, which your lords get that at page 55. Paragraph 20, yes, my lord, page 62 onwards. Please come to para, my lord, 19 at page 63. Hindustan Times, my lord, is taken into account. And, my lord, consistently held. These are all penal consequences. Therefore, you can't levy the amount, the full amount. And I also pointed out, my lord, this honorable court has specifically held, page 47, that the authorities themselves, page 47, paragraph 19 of that earlier judgment, last 4 lines. It is submitted that the appellate authority has in many appeals restricted the damages to 15% of the areas of contribution to meet the ends of justice, which consideration is not forthcoming from the order impugned. Therefore, my lord, they quash it. This honorable court has quashed it. And my lord, I paid the interest. It's not as if I did not pay interest, my lord. Whatever the delay, 6 days delay, 1 day's delay, 3 days delay, everything, my lord, I paid interest. 41 lakhs admitted. In such a circumstance, whether, my lord, penalty should be levied. I, my lord, did not get the funds. I did not, my lord, withhold anything. Moment, my lord, I got the amount, my lord, from the employer, my lord, my employers. I paid, my lord, the contribution. I paid the salaries to the employees, my lord. I did not withhold it, notwithstanding, my lord, my difficulties. 2 crores is the amount due. Therefore, my lord, my submission is a long delay, 1. Secondly, my lord, penalty, my lord, cannot be, my lord, imposed as a matter of routine course. Third is, these are penal consequences. That's all, my lord. Grateful to your lordship. Please. And none of the judgments, my lord, which have been cited by me are all, my lord, they are parties to it. In none of them, my lord, they have filed any appeal. They have accepted the judgment as correct judgment, my lord. That's another thing, my lord. Yes. The Provident Fund Commissioner is a party to all of them. 5 judgments, my lord, I have kept in my list. All of them, my lord, this honorable court has quashed it. And my lord, they accepted it as the correct view. That's all, my lord. Grateful.
45, Sri Shilwant Vijay Kumar Maheshwarappa, Sri Vishwajit Sadananda, Srimati Lakshmi Menon.
Your lordships, appearing for respondent number 4, your lordships. If I may kindly seek time, your lordship, my senior has been diagnosed with COVID.
We are dismissing it under for default, none for petition. Even when not called away, appears not interested, dismiss.
A final hearing.
Much obliged.
We do here and remaining written. Type it now. Sir has validity of the order dated 11/2020 passed by the central government Justice Tribunal from Labour Court, as well as order dated 24/25/2015 passed by the Regional Provident Fund Commissioner. The petitioner also direction to the Regional Provident Fund Commissioner -Roman 2 within bracket recovery not to take another application. The petitioner's challenge to the impugned order, few facts need mention which are taken in fact. The petitioner is a company incorporated under the provisions of Companies Act 1956 and is engaged in the business of providing security services, security guards to various industries, establishments throughout the country. Full stop. The petitioner has around 1,000 employees on its road. The petitioner is covered by the provisions of Employees Provident Fund and Miscellaneous Provisions Act 1952, hereinafter referred to as the Act. Petitioner has been making payment towards the Employees Provident Fund contribution. However, it appears that there was a delay in remitting the Employees Provident Fund contribution for a period from March 2003, delay of few days from March 2003 However, there was a delay ranging between 9 days. $360 depositing in remitting the amount of provident employees provident fund contribution for a period from March 2003 till September 2013. So cause notice dated 16/12/2013 was issued to the petitioner, by which the petitioner was asked to show cause as to why penalty under section 7Q of the Act, as well as damages under section 14B of the Act, be not imposed on it for the delay in remitting the amount of provident fund contribution for the period from 1/4/1996 till 16/12/2003. 15/12/2013. The petitioner thereupon submitted detailed objections on 2/12/2014 and 19/12/2014, disputing the demand full stopping the objections it was inter alia pleaded that that show cause notice uh, issued issued by the respondent for a period from April 1996 to December 2013 is belated and has been issued after unreasonable delay in issuing the same. So it was also pointed out that there was some delay in remitting the provident fund contribution due to due to severe financial difficulty and delay in payment by the customers to the petitioner, and therefore the uh, delay in remitting the provident fund contribution is unintentional. However, however, the Regional Provident Fund Commissioner by an order dated 24th of the 25th February 2015 passed an order levying damages to the extent of rupees 79 lakhs 29,768 as per section 14B of the Act, and by another order passed on the same date levied interest under section 7Q of the Act to the tune of rupees 41,40,013 of the Act. The petitioner admittedly has deposited the amount of interest levied under section 7Q of the Act to the extent of rupees 41,40,013 paragraph. The being aggrieved, the petitioner filed an appeal before the Employees Provident Fund Appellate Tribunal, hereinafter referred to as the tribunal. Full stop. The tribunal an order dated 11/2/2020 dismissed the appeal referred by the petitioner. The aforesaid factual background, the petition has been filed. We are counsel for the petitioner admitted that so called notice dated 16/12/2013 was issued to the petitioner after an inordinate delay of 17 years. It is further submitted that the orders passed by the Regional Provident Fund Commissioner as well as the tribunal are cryptic and suffer from the vice of non-application of mind. It is also urged that the authorities ought to have appreciated that there was delay in remitting the provident fund contribution due to reasons beyond the control of the petitioner, and delay in remitting the amount of provident fund contribution was unintentional and bona fide. Full stop. This connection, Learned Senior Counsel has invited the attention of this court to the list of sundry debtors to customers of the petitioner for a period from 2008 to 2011 in support of its contention that the payment of payments were due to the petitioner. It is also submitted not unreasonable delay, what you have so-called notice issued after unreasonable delay.
Inordinate delay of 17 years.
17 years, full stop, huh? It is urged that even though no limitation has been prescribed for initiation of the proceeding in respect of the default which may be committed by the employer, it is argued that such power should be exercised within a period of within a reasonable time. Thereafter, what is the last sentence?
In this connection, the same person has invited you.
It is also urged that then thereafter it is also urged that in terms of section 14B of the Act, that under section 14B of the Act, the authority has discretion either to levy or not to levy such penalty damages by taking into account the facts and circumstances of the case. Full stop. In support of aforesaid submissions, plans has been placed on decisions in report will come in the paragraph on the other hand, the counsel for the respondent. The counsel for the respondent submitted that. On the other hand, the counsel for respondent submitted that the provisions of the Act is a provisions of the Act that the Act not provision, that the Act is a social welfare legislation, and in view of second proviso in section 14B of the Act, the adjudicating authority has no discretion to levy the damages, to levy less damages. Full stop. It is submitted that the damages have been levied in accordance with para 32 capital A and para 38 of the Employees Provident Fund scheme 1952. It is submitted that the adjudicating authority under the Act is a quasi-judicial body, and it is required to and it is bound to assign reasons for its orders. It is also submitted that financial hardship is not a ground to waive the damages under section 14B of the Act. In support of aforesaid submission, learned counsel for respondents has placed a plan from
Final hearing, number 46, CTA Karumbaya.
My lord, I am for the response. I am for the response, my lord.
Government advocate.
My lord, my name is not shown. I request your lordship to have it next week, my lord. I am for the authority, my lord.
SV Desai, Learned Council appears for
Respondent to 192, my lord.
respondent 1 and submits that his name has not been mentioned in the offices. He therefore pays for adjournment. Office is directed to reflect his name as counsel for name of Mr. Desai as counsel P.N. Desai.
SV Desai.
Counsel correspondent SV Desai. SV Desai as counsel correspondent number 1 and 2. This next week.
2 weeks, my lord. 2 weeks, my lord. A week after next.
He said next week, sir, 11 years have passed. Please be considerate.
Please.
Today, even though his name has not appeared, he knows that case is listed.
Please.
But despite that, he is seeking adjournment, so we have granted it.
Please.
But be reasonable. 2010 petition. 11 years have passed.
Number 48, CT Sheshagiri Rao, government advocate.
I appear for KIADB all these cases.
Yogesh C. Nayak, SG Hegde, M. Shiv Prakash.
I appear for KIADB in all these cases, my lord. In some cases, KIADB is appellant. In some cases, KIADB is, my lord, respondent. I am ready, my lord. The issue is
They are bench having tax and advisement.
My lord, I appear for the petitioner in the writ petition 34335, that is 45.8 minutes.
55.8.
48.5 minutes.
Right.
Yes. My lord, according to us, my lord, is fairly covered by a judgment of the Honorable Supreme Court in Kenchappa's case, my lord. And if they argue their writ appeals, my lord, we will address our arguments on the writ petitions also.
my lords.
Yes, Mr. Bo. Yes,
My
Mr.
My lords, with one, my lord, writ appeal, I have filed, my lord, synopsis, my lord, list of citations and also some documents. That is writ appeal number 531.
That's fine, Mr. But other councils are not appearing. So we will pass it over for a file, Mr. Saprat.
Please.
Number 49, Sri Lohita Shobhanakar, Sri D.
My lord, I'm appearing for the petitioner in this matter, my lord. We'll file the NOC wakalat in, so kindly the matter may be adjourned by 2 weeks, my lord.
And for the petition, my lord, kindly date my name, my lord.
Adjournment after 9 years. So what will you do? This will be the last day of this case in the court. So there is no question of filing NOC wakalat, you argue.
My lord, we were instructed by the client that they'll be giving us the NOC wakalat, my lord. We still haven't received the papers or the filings, my lord.
Don't appear if you don't have instructions.
My lord, we seek instructions, my lord. So if my lord may be pleased to adjourn the matter by 2 weeks, we'll seek instructions and we'll do the needful, my lord.
No, madam, in all cases, I mean, all of you, without this thing, any thinking, you seek adjournment in a routine matter, all cases. It's really unfortunate. Why you should not file the NOC wakalat, supposing if we refuse to grant time and we say that you don't have any instructions and dismiss the petition, what can you do? Go file SLP. What is this after 9 years? What for you are seeking time? It will come up next week. If you don't argue, we will dismiss it.
Much obliged.
My lord, I'm for the petitioner, my lord. I'm our name may be written. Loitashpur Banakar.
This is directed to delete the name of Mr. So-and-so, Banakar, and what?
Madam, your name, madam?
And to reflect the name of
Surabhi, my lord, Vindhya V, my lord. For KNS.
Your name, madam?
Vindhya V, my lord.
No, whose name is who is appearing?
My lord, Shaman Nayak will be appearing, my lord.
This is a different case.
Madam, spell it properly, madam.
My lord, is this, are you addressing me, my lord?
Yes, yes, madam.
My lord, SHAM ANTH NAIK.
Reflect the name of so-and-so. Write her name. Praise for adjournment.
Your name, madam?
VINDHYA, my lord.
Yeah, VINDHY. Then it council prays for adjournment. Yes, next week. It is made clear that no further adjournment shall be granted.
Much obliged, ma'am.
No, you prepare the case pattern instead of the book. Like, get ready. Study the file.
Number 50, the case is Shankumar.
I appear for the counsel.
Yes.
Petitioner, madam. What is questioned is, my lords, the direction issued by the State Human Rights Commission to the state government to take disciplinary action against the petitioners. It is questioned on two grounds, my lords. One is,
but who appears? You just let us ascertain who appears for responding.
Suresh Desai. Is Suresh Desai? Government advocate?
No, he is not there, Mr. Desai. Shall we pass it over, Mr.?
Lord, say instead of passing over tomorrow, because 2:30 I have a part-time matter, then I should not be.
All right, day after. Day after.
Grateful.
Very senior counsel for the petitioner. None for respondent number 2. Awaiting appearance of none for respondent number 2. Awaiting appearance, line below. Awaiting appearance of learned counsel for respondent number 2. Hearing of the petition is deferred. List on whatever 4th of February 2020.
And 10 minutes, my lords, on either side.
4th February.
Mutton is there.
Number 51, Srimati Tannai Rajkumar, Sri KV Arvind.
Yes, madam.
My lords, I'm appearing for the appellant. I have request for 2 weeks accommodation in this matter, my lords.
2013 matter. Like her name. KV Arvind, learned counsel for revenue. Learned counsel for the SSC. Praise for examination. Just after 2 weeks.
Much obliged.
52.
Lordship, appear for the appellant in this matter, my lordship. May I request 2 weeks' time, my lord?
Right.
My lord, I'm appearing in serial number 52.1, my lord. May I request 2 weeks' time, my lord?
52.1, Mr. Bhairav, learned counsel for the SSC, praise for adjournment to enable him to prepare the case and argue the same. Line between this after 2 weeks.
Greatly obliged, my lord.
Sri T. Sheshagiri Rao, Sri G. Lakshmi Rao.
But I add to the respondent, my lords. I'm ready with the matter, my lords.
Minutes.
Where is?
I'm here.
Yes, yes.
Yes, minutes. Minutes. This is, of course, questioning a part of the acquisition, and minutes, the interest of the petitioner is with respect to a small part of the land therein, which is in the nature of a site. Minutes. Could I would put it in this way, minutes. May I propose this, that this list may also be resolved in another way in view of the amendment to the BDA Act. Minutes, where insofar as certain illegal occupations are concerned, minutes, 38D has been inserted to the BDA Act, minutes, where it can be regularized by payment of certain market value as prescribed within the Act. 1 minute, I would question the acquisition for the purpose of a very small site. My holding would come up to around 4,000 square feet. In view of 38D minutes, there is an option for me to have this regularized. If my learned counterpart could just verify minutes that this is not a site which has been allotted to some other allottee, then at that point, then minutes, I think I can probably avail the benefit of 38D.
That is not the scope of the writ petition, my lords. The scope of the writ petition is only with reference to lapsing of scheme under section 27 of the Act in respect of OMBR layout, my lords. This matter is fully covered by your lordship's decision in writ appeal number 1548 of 2014, my lords. Your lordships have already upheld the notification issued for the OMBR layout, my lords. I have already furnished the copy of the said judgment along with the court officer, my lords.
Mr. Rao, what do you say?
I would put it in this way, minutes. During the minutes pendency of this writ petition, there has been a statutory amendment to the BDA Act, where minutes categories of such litigants have been identified, minutes, and for the benefit of whom, if your lordship could just see 38D.
You do whatever you want to apply to BDA, withdraw this.
Why I am putting this? I know that
not be a party to any sort of a direction giving rise to another writ petition.
That's the exact reason, minutes, I said. If my learned friend could, minutes, just verify.
You verify. It's not this thing that you file a petition and the other council will verify after how many years? 8
not
years.
That, has this subject matter been a subject matter of any allotment? If that can, only to that extent it can be verified. Me verifying will take a lot of time in the PDA. Minutes.
What is the relief for?
Minutes, it is
subject matter of this thing is not this is refrain from asserting any right.
Not much, minutes. Not much. I have to be. No, minutes. It is about the OMBR layout and the implementation of the scheme. We were there before this court, the very same premise, minutes, that the scheme has lapsed because of the fact that no possession has been taken over insofar as these lands were concerned for the past many years. And minutes, there are documentation, minutes, which is unrebutted so far by the BDA, which discloses our possession, minutes, for the past 20 years. Be my predecessors in interest. So under these circumstances, minutes, now in view of section 38D, minutes, there used to be a loss to the exchequer. That is why 38D got introduced into the statute. The fact of the matter remains, minutes, that despite, minutes, the scheme being launched in the year 1977, these tracts of land, minutes, were isolated pockets which were not capable of being implemented within the scheme. No sites were formed, minutes, as per the BDA, as contemplated by the BDA, and the possession of which was not taken at any given point of time. Under the given circumstances, minutes,
yes,
the scheme was sought to be declared as having been lapsed under section 27 of the BDA Act. That is the main prayer in the writ petition. Now, minutes, just in order to verify, here we are not concerned with the validity of the scheme, which is there before this court. We are only concerned with the lapsing of the scheme, minutes, because at no point of time, minutes, the possession of the property had been taken over by the BDA. And your lordships may kindly see, insofar as the documents are concerned, at annexure, running page 53, my lords, annexure E3. These properties now, my lords, have come within the urban agglomeration limits of the BBMP. My lords, it has been assessed for fiscal purposes. Taxes are being paid to the BBMP. Annexure E3 too. E5 there too. These very facts not would disclose that the possession of this part of the land was not taken over. For the BDA, in order to rebut it, otherwise, they would have to probably establish that the possession of the land was taken, and consequently, the original owners were dispossessed in a manner known to law, and thereafter, they have implemented the scheme by formation of a layout, and this land, particular land, in which they have formed a layout, has been allotted in favor of some allottee. If all these factors are taken into account, and probably they are able to demonstrate that the physical possession was ousted, I cease to have a case before this court. On the contrary, my lords, if I remain in possession, and my lords, by neighboring tracts are also in the same way, my lords, where the BDA has not implemented its scheme, I am before this court, my lords, claiming that let the scheme, insofar as this site petition schedule property be declared as lapsed. That is the prayer. Now, my lords, I requested the court in the horse amendment. There is a statutory scheme itself now in view of 38D. This is where, my lords, I pointed out at the beginning itself. Now, my lords, this site or this plot, my lords, whatever the BDA would do with it, either, my lords, it has to allot it in favor of some other allottee, and, my lords, it has to collect some amount of money to that effect. Or, my lords, statute has given such land losers an option, my lords, where to the extent of 4,000 square feet, my lords, their possession can be regularized by payment of certain value as indicated in the statute. To that extent, my lords, it is a statutory enactment which has come into effect, my lords, in the year 2020. Hence, my lords, my plea is, in view of this 38D, my lords, my claim under the sale deed.
38D has come into force in 2020.
Yes, your lords. Yes, during the
so then it applies with retrospective operation to everybody, right?
Yes, my lords.
Huh? Okay.
Your lordships may kindly see. May I, may I read the statement of objects of that act? Probably, if it is the amending act.
That, see, your contention is twofold. That possession of the property has not been taken over by the BDA. Yes, therefore, the scheme has lapsed. Yes. And this possession, your possession can be regularized under section 38D. Therefore, they should be directed that your possession should be regularized. These are the two submissions.
Not the possession, not. May I just put it in this way? I'm sorry. It is, my lords, the scheme postulates like this. I will just read this for one moment. I'm sorry, I may take your lordship's time. But I would, if the statement of objects and reasons of Act 27 of 2020 is there, may I take your lordships to that for a moment? It is considered necessary to amend the Bangalore Development Authority Act 1976 to allot the BDA sites to the original owner or purchaser. Not here, there is a difference. Original owner or purchaser thereof.
Or what notice after notification you have purchased the property, Mr. Rao.
Yes,
some point of time you have to be fair to the court, right?
Yes, yes.
You owe duty being an officer, and we expect this from you.
Absolutely, absolutely.
All the time you don't have to hammer. I mean, this thing, you are a subsequent purchaser after issuance of notification issued under 4.1 and 6.1. What rights do you have? How you can challenge anything? What right?
That is why I am recasting my submissions to limiting it to 38D. That where
so therefore they should be directed under 38D to confer title on you and to make payment of compensation to you. BDA for harassing you.
Not compensation to me.
So
I have to pay the BDA.
No, you have to. Because of BDA, you are in the court waiting for 8 years. So they should compensate you. This is the submission, right?
No. That's not the submission.
No. The 38D, they should confer title and make you feel like a king. That's the submission.
That's
right.
not the That's not the
What is it? And what?
The submission is only this. The BDA realized that in various of its schemes.
Mr. Rao, at times you should appreciate humor also, right?
I got that.
Whatever you say. Yes, go ahead. I understood. No, what 38D they should confer title. Whatever you are repeatedly telling us that.
May I, my lord? Yes. Just for the background is like this, my lords. In various schemes where BDA implemented, my lords, there were portions of plots where, my lords, the layout could not be implemented because, my lords, various constructions used to come up within those places.
They should be directed to allot the land in your favor. That's all. That's what you are saying.
This, in terms of 38D, my lords, they collect a statutory market fee, the amount to be levied and collected.
All right. So we have understood. It's not that difficult. They should be directed to allot the land in your favor under 38D.
Yes.
Fine.
Now,
yes.
The next point is, your lordships ask me.
What remains once it is allotted to you? What remains?
Not much. I think my grievance will be mitigated to that.
That's it. Yes, Mr. Rao.
My lords, Lord, this writ petition is filed after an inordinate delay of 33 years, my lord. This may be taken note of, my lords. Because I have already filed a brief synopsis before this honorable court, my lords.
Where is that?
Yes, the preliminary notification was issued in the year 1977, my lords.
Where's this move?
Final, your lordship gets it, my lords.
Yes, yes.
Lords, preliminary notification on 3/11/1977, final notification on 13th November 1980. Lord, the award was passed on 8/7/1982. Award was approved on 22/1/1983. And possession was taken on 9/2/1983, my lords. Notification under 16(2) was also issued on 27/5/1983. Lord, this writ petition was filed in the year 2013, my lords. Therefore, it is barred with, lords, I am relying on Banda Development Corporation, my lords, para number 19. I have already furnished a compilation of citations, my lords. 3 judgments I have cited before this court, my lords. Paragraph number 19, my lords. Where in which...
Okay.
In matters involving challenge to acquisition of land for public purpose, the court has consistently held that delay in filing a writ petition should be viewed seriously and relief denied to the petitioner if he fails to offer plausible explanation for the delay. This is first point, my lord. The second issue is, my lords, he is a subsequent purchaser, my lords. My lords, in view of the judgment of the Honorable Supreme Court in Meera Sahani versus 2008-9 SCC 177, and also the latest judgment of the Honorable Supreme Court in Shivakumar versus Union of India, that is reported in 2019-10 SCC 229. Lord, this judgment was today morning, my lords. I furnished to the court officer, my lords.
Which paragraph in Meera Sahani?
Meera Sahani, my lords, paragraph number 17.
And what is in 2019-10, which paragraph?
In Shivakumar's case, my lords, paragraph number 19, 20, and 21.
Correct.
The Honorable Supreme Court says the sale deed is void ab initio. There is no question of even claiming lapsing of scheme before the Honorable Court, my lords. My lord, the third submission is, my lord, scheme has been implemented, my lords. My lords, I have furnished, along with the statement of objections, I have culled out the details by way of a tabular column, my lords. Totally, my lord, 341.07 acres of land been acquired, out of which possession was taken in respect of 244.26 guntas of land. Out of which, my lords, we have formed as
44.26,
my lords. of which, my lord, 178 acre, 36 guntas of land, we have already formed a layout. Totally, my lords, 2097 sites have been formed. My lord, the CS sites, 6 parks have been found, 9 CS sites have been formed by the BDA. My lord, the scheme has been substantially implemented, my lords. My lords, in view of offshore development case, my lords, that also I have furnished to the Honorable Court, my lords. In paragraph number 38, my lords, once the land is vested in the state, my lords, it cannot be reverted back to the landowner only because the scheme is, assuming for a moment the scheme is lapsed, because the acquisition has attained finality, the land is vested in the state.
That's it.
That is in 2011, my lords, this argument of 38D is, my lords, completely outside the scope of this writ petition, my lords. There is no cause of action, there is no pleading, nothing is there. It's a separate cause of action. It is for him to agitate his rights elsewhere, my lords, not in this writ petition, my lords. My lord, this Honorable Court has already held in writ appeal number 1548 of 2014, my lords, upheld the appeal preferred by the BDA. In upholding the acquisition proceedings, a scheme is upheld. My lord, decided on 24th June 2021.
That's it.
Yes, grateful.
May I just only supplement it in form of 2 submissions? It's not. Insofar as the positions of law, what has been quoted, I don't think there should be any dispute with respect to that. And there are propositions with respect to the facts of which the courts have decided. Insofar as the aspect whether 38D can be pleaded by a subsequent purchaser or not, the statement of objects of the said amending act makes it clear that it is for the land loser, unauthorized occupant, as well as the purchaser thereof, insofar as 38D is concerned. And that is why, I said, one thing is to go on the validity of the scheme. If your lordships are deciding or have decided on the validity of the scheme, it would be unfair on me to elaborate it once again. But any which way, there is a pertinent submission which has been made by the other side. 324 acres of land has been acquired, out of which 244 acres have been taken possession of. Out of which 178 acres have been formed as a layout. In other words, by what I understand, almost 150 acres of land has gone out of this acquisition. It was for the very same reason that there was a loss to the BDA, and hence 38D has come into effect. For whatever is already embedded within the statute, and by the language of which 38D is seen, it is for schemes where which has taken which have gone by in the past, and these benefits are available to such number of people who have been specified in the objection reasons. Hence, ultimately, by formation of sites and dispersing the same to the allottees, the BDA would be ultimately ensuring some sort of a financial benefit, which now the government has said, the legislators have said, even these unauthorized occupants are entitled to have the very same site regularized because of their prevalent settled possession, which the BDA does not dispute in my case. They said it is settled possession, but for the fact that the scheme is to be implemented there too. But it would render the rights of these parties redundant for so long. Hence, my plea is, one thing is about the validity of the scheme. I would not touch upon that. But, since there is a statutory amendment to section 38D, and in order to avoid future litigation to that effect, by going again and producing an inquiry, holding an inquiry to that effect, that can be avoided if there is a direction for the BDA to consider this, consider the case, and hold an inquiry in terms of 38C. That would suffice, that would suffice. It is not that they would grant me directly. They will have to hold an inquiry in terms of 38C. See, whether my settled position is there, and thereafter, they will come to the conclusion. That is all what I requested, because this is a scheme which is already there in the statute. That would be my submission. I'm grateful for the audience.
Yes, 54.
Let's,
Number 54, Sri K.V. Arvind, Sri Sandeep Kuilwar.
I appear for the respondent, Your Honor.
That's this batch matter, my lords, may kindly consider, my lord, to have it after 2 weeks, my lord. If it would, for convenience, my lord, it may be physical hearing, may be convenient, my lord. That I'll take a chance after 1 or 2 weeks.
Learned counsel for the SOC. This K.V. Arvind, learned counsel for the revenue. Madam. Write her name, tell.
She will take.
Learned counsel for the SOC, learned counsel for the revenue. Wait for adjournment. List after 2 weeks.
My lord, just one submission. If the name of Ms. Tanmay Rajkumar could be reflected on behalf of the respondent.
Then yes, 54, then mark her presence. Then say office is directed to reflect the name of Ms. Tanmay Rajkumar. Then say learned counsel for revenue, place for adjournment. It's after 2 weeks.
55, Sri D.R. Vishwanath, Sri K.V. Arvind.
Mr. Arvind, who is there?
Lord, I think one Mr. Vishwanath, my lord, is appearing in this matter.
For the applicant, Mr. K.V. Arvind, learned counsel for the revenue, list after 2 weeks.
Number 56, Srimati Tanmay Rajkumar, Sri K.V. Arvind.
Yes.
My lord, if this matter could kindly be taken up on the 11th of February, my lord. Mr. Percy has been engaged in this matter.
Her name is Mahima Ghosh, learned counsel for the applicant submits, and Mr. K.V. Arvind, learned counsel for the revenue, learned counsel for the applicant submits that that the matter has to be argued by Mr. Percy Partiwala, an outstation counsel. Mr. Percy Partiwala. Then Mr. I don't know.
ERC will take. ERC will proceed.
Right. Therefore, submits that the matter be taken up on 11th of February 2022. List on 11th February 2022.
Much obliged.
Number 57, Sri Pratik Jain, A.C. A. Sanmati, Sri K.V. Arvind.
Appear for appellant, respondent. No.
For appellant, A. Sanmati, learned counsel for respondent, awaiting appearance of learned counsel for the appellant, hearing of the appeal is deferred. List after 1 week. 1 week, Mr. Sanmati.
58, Sri K.V. Arvind, Sri M. Lava.
May I request 2 weeks time in this matter, my lordship?
58, Mr. K.V. Arvind, learned counsel for the revenue. Mr. Bhairav, learned counsel for respondent. SSC, learned counsel for the SSC, place for adjournment. List after 2 weeks.
My lordship, one additional request, my lordship. This matter, ITA 117 requires to be clubbed with ITA 118, my lord. They're connected matters, my lord.
Just along with, then say list after 2 weeks, you have written, along with ITA number 118/2016.
Greatly obliged, my lord.
You don't know.
59, Sri M. Lava, Sri K.V. Arvind.
Lordship, may I request 2 weeks time in this matter as well, my lord?
In order. Not say list after learned counsel, right? Mr. S. Bhairav, learned counsel for the SSC. Mr. K.V. Arvind, learned counsel for the revenue, learned counsel for the SSC, place for adjournment. List after 2 weeks.
Number 60,
Obliged.
Sri B.R. Vishwanath, Sri K.V. Arvind.
After.
And again, same council, my lord, at 55.
And for the applicant, Mr. K.V. Arvind, learned counsel for the revenue. Line below, awaiting appearance of learned counsel for the SSC, Hearing of the appeal is deferred this after 2 weeks.
61, Sri M. Lava, Sri K.V. Arvind. Lordship, may I request 2 weeks' time in this matter, my lord?
Learned counsel for the SSC prays for adjournment this after 2 weeks.
62, Sri B.S. Balachandran, Sri
Your
K.V.
Lordship,
Arvind.
I am appealing. Next week it may be taken, Your Lordship, on 11th.
Yes, Mr. Arvind, 11th. B.S. Balachandran, learned counsel for.
But because it is 11th, my lord, Friday, my lord.
Why Friday, Mr. K.V. Arvind, learned counsel for.
Because your lordship's posted, my lord, Mr. Padiwala's matter. That is a very lengthy matter.
Learned counsel for the SSC prays for adjournment. Yes, Mr. Tell some other.
2 weeks may be given, Your Lordship. I will leave it to you.
14th February, Monday.
Much obliged, Your Lordship.
Just on, prays for adjournment, just on 14th February 2022.
Grateful, Your Lordship.
63, Sri Tata Krishna, Sri K.V.
Appearing
Arvind.
for the appellant, Your Lordship, it involves transfer pricing matters, Your Lordship.
Mr. Sharath, learned counsel for the SSC, Mr. K.V. Arvind, learned counsel for the revenue, learned counsel for the SSC submits that the issue pertains in this appeal to transfer pricing, which is pending adjudication before the Supreme Court. Paragraph in view of opposite submission, hearing of the appeal is deferred, list after 3 weeks.
Obliged.
64, Sri
My lord.
Dorela, Sridhar Prabhu, Government
My lord,
Advocate, Sri K.T., Sri N.K. Ramesh.
Appearing for the petitioner, my lord, as per the direction of this honorable court, on the last date, I have duly submitted an application to implead respondent number 5, the medical college, MS Ramaiah College. And along with that, I have also filed an application to amend the petition, my lord. Kindly, these applications might be accepted.
What amendment? You are seeking compensation?
Yes, my lord.
So nothing, you are trying to, infuse light into a dead thing, right? By this amendment. This petition has become infructuous, right?
My lord, the
as on today.
My lord,
it has
the
become
fees.
infructuous. You want to resurrect it by amending it.
No, my lord. No, my lords.
It is survived. Then why the amendment?
The students.
Let's
the
see what is
student.
the relief 64. Yes, what is it?
My lord, kindly pass it over. The senior will submit, my lord.
Just a minute. We'll consider it at the time of hearing. You argue.
Lord, I'm sorry, my lord, I could not. I'm sorry, my lord, I was held up in the. This matter, my lord, challenges the fee structure. And my lord, on the last occasion, my lord, we had not implemented the college, my lord, which has collected the fee. And my lord, the fee is collected by the college. Though, my lord, a committee is now constituted by the state government, which determines the fee structure, my lord. The fee is collected in violation of that statutory mandate.
Where is that IA? Which IA you have filed?
IA, my lord, we have filed. My lord,
which IA?
Yes, we have filed it on, my lord, 16th of January, my lord. Sorry, 16th of. Yes, lordships will take, my lord, the IA. This, it is filed in for interlocutory application for impleading, my lord. In December 2021, Lord. I'm sorry.
To notice, Mr. Sridhar, heard on the Sridhar Prabhu Learned Counsel for the petitioner, heard on IA, interlocutory application and application seeking improvement. Issue notice, line below, issue notice of the apported application to be proposed respondent.
Deeply obliged, my lord.
65.
I appear for the respondent, my lords.
Oh, yes, madam, what do you want?
Well, we were given to understand that the department would...
It is serial number 65, my lord. This is against, my lord, cancellation of registration under 12A, my lord, to the society, my lord, the carrying on, my lord, running medical colleges and all, on the ground that, my lord, there were some violations.
Hey, why do you always give her an impression that you will seek an adjournment? She repeatedly tells the court. Madam repeatedly tells her that she is given to understand that revenue would seek an adjournment.
That just to save time, my lord.
All right, yes, please.
This is on the basis of, my lord, certain incriminating material, my lord, found in the course of search and assessments were made. On that basis, my lord, the cancel registration was cancelled. The assessments, my lord, were carried in appeal before the tribunal. The tribunal, my lord, has knocked off those additions, my lord. Against that, my lord, the revenue is in appeal before this honorable court. Those appeals, my lord, just in a short time, my lord, I'll furnish the numbers. This appeal has to be taken along with that, my lord.
When do you want? Next week?
That is, I think that matters has to come up, my lord, for admission, my lord, next week, my lord, or week after next, my lord.
KV Arvind, there is counsel for the revenue. Mahima counsel for assessing. Counsel for the revenue press for adjournment. This after 2 weeks. Then what about 66 and 67?
66, I think, my lord, it can go on, my lord, immediately after lunch.
66 and 67.
66 on, my lord, 67 assessees appeal.
What?
My lord, 66 can go on, my lord. 67 and 68, your lordship may consider 2 weeks' time, my lord.
Yes,
66. Please, my lord.
67 and 68, Mr. A. Shankar Lanit, Senior Counsel for the assessing, Mr. KV Arvind Lanit, Counsel for the revenue, Lanit, Counsel for the assessing place for adjournment, list after 2 weeks. So, how much time will you take in 66, Mr. Shankar?
45 minutes, my lord. 30 minutes. I'll complete
30.
it. 30 minutes, my lord.
30 minutes. That's better.
Only 30 minutes.
Yes.
I will measure my time also. Very small matter.
Yes.
We'll finish it, my lord.
Court officer.
Court officer, serial number 30. ಏನಾಯ್ತು?
Court officer. Court officer 50 ಪಾಸ್ ಆಗಿದೆಯಾ? ಹೌದು.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 30 ಏನಾಯ್ತು? ಪ್ರೀವಿರಾ? ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 30.
ಡಿಸ್ಮಿಸ್ ಆಯ್ತು ಸರ್. ನಾನ್ ಪ್ರಾಸಿಕ್ಯೂಷನ್.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 48
ಡಿಸ್ಮಿಸ್. ಸೀರಿಯಲ್ ನಂಬರ್
48
is pass over.
Serial number
45, man. 45. Serial number 45 is DNP. Dismissed.
ಸೀರಿಯಲ್ ನಂಬರ್ 30 ಏನಾಯ್ತು ಮೇಡಮ್?
ಸೀರಿಯಲ್ ನಂಬರ್
30.
ಅದನ್ನ ಹೇಳಿದ್ ಸರ್, DNP ಆಯ್ತು.
ಡಿಸ್ಮಿಸ್ ಓಕೆ.
ಆಫ್ಟರ್ ಲಂಚ್ ಫಸ್ಟ್ ಪಾಸ್ ಓವರ್ ತಗೋತಾರೋ ಅಥವಾ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೋ?
ಲಿಸ್ಟ್ ಕಂಟಿನ್ಯೂ ಮಾಡ್ಬೋದು, ಇಲ್ಲ ಸೀರಿಯಲ್ ನಂಬರ್ 48 ಕರೀಬಹುದು. ಸೀರಿಯಲ್ ನಂಬರ್ 75 ಇದೆ ಸರ್.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮೆಮೊ ಫಾರ್ ಪೋಸ್ಟಿಂಗ್ಸ್ ತಗೊಂಡಿದ್ದಾರಾ?
ಇಲ್ಲ ಕೋರ್ಟಲ್ಲಿ ಇಲ್ಲ ಸರ್, ಅಲ್ಲಿ ನೀವು ಇಮೇಲ್ ಮೆಮೊ ಮಾಡಬೇಕು.
ಅಲ್ಲ 81 and 82 ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಸೀರಿಯಲ್ ನಂಬರ್ಸ್ 82 ಮೆಮೊ ಫಾರ್ ಪೋಸ್ಟಿಂಗ್ ಅಂತಿದೆ.
ಮೆಮೊ ಫಾರ್ ಪೋಸ್ಟಿಂಗ್ ಅಂತ ಇದೆ. ಮೆಮೊ ಫಾರ್ ಪೋಸ್ಟಿಂಗ್ ಅದೇ ಇಮೇಲ್ ಮೆಮೋಸ್ ಇರಬಹುದು ಸರ್. ಅದಲ್ಲ 81 and 82 ಇಮೇಲ್ ಮೆಮೋಸ್ ಸರ್.
ಹೌದು, ಅದು ಕೇಳ್ತಾರಾ ಇಲ್ಲ ಮೆಮೊ ಏನಾದರೂ ಆರ್ಡರ್ ಮಾಡಿದಾರಾ? ಡೇಟ್ ಏನಾದರೂ?
ಏನು ಮಾಡಿಲ್ಲ, ತಗೋತಾರೆ ಬಟ್ ಡೇಟ್ ಕೊಡ್ಬೋದು.
ಅದೇ ಡೇಟ್
ನಿಮ್ಮನ್ನ ಕೇಳ್ಕೊಳ್ತಾರೆ ಸರ್.
ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.
Serial number 77.
Number 77 ಇದೆ ಮೇಡಮ್.
Thank you, ma'am.
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 31. ಸೀರಿಯಲ್ ನಂಬರ್ 31
14-2. ಅಡ್ಮಿಟ್ ಆಯ್ತು
31-14
ಹೌದು
31
ಹೌದು ಸರ್ 31-14-2 ಆಯ್ತು ಅಡ್ಮಿಟ್ ಆಯ್ತು ಎಮರ್ಜೆನ್ಸಿ ನೋಟಿಸ್ ಆಯ್ತು
32 ಡಿಸ್ಮಿಸ್ ಆಯ್ತಾ 30 ಡಿಸ್ಮಿಸ್ ಆಯ್ತಾ
30 ಹೌದು ಸರ್ ಇದು ಮೂರನೇ ಸತಿ ನೀವು ಕೇಳ್ತಾ ಇರೋದು
Court officer 69.
26 DNP ಆಯ್ತು ಹಾ
Court
ಸರ್ ಹೇಳಿ
officer
ಸರ್ ಇನ್ನೊಂದ್ಸತಿ
69, madam, 69.
69 ಇದೆ ಸರ್
ಇದೆ ಅಲ್ಲ madam? Thank you.
ಹೌದು
Madam, 47.
47 list after 2 weeks.
List after 2 weeks. Huh? Madam. Okay.